He
I
mentioned
mentioned a suit for administration of a Devottar estate, private estate.
Yes.
My lord, the plaint in the original record was not traceable. Later on, a copy of the plaint has been found in the records. An order of reconstruction of the plaint has to be passed by this honorable court. May this matter appear any
To be
day, my lord,
mentioned.
to be mentioned, yes.
My lord, may I be permitted to mention a matter from the list of Justice Sugato Mujumdar, my lord? My lord has the urgent determination.
Yes.
And there's an interim order which is expiring today, my lord.
Interim order will expire today. Which item number?
My lord, this is in the list of
No, yes, Justice Majumdar's
Yes.
list. It is appearing in the list.
no, my lord, it is not. It is not. It is not in the list, my lord.
The interim order will expire today.
Yes, my lord.
So let it appear tomorrow as to be mentioned.
My lord, the order will expire today, so if it can be taken up as in the second half as a supplementary.
So again, a list has to be prepared for that.
Yes,
So
my
it's
lord,
better tomorrow. Tomorrow his
my
lordship
lord,
will
but
be
Lordship,
the-
we have a similar prayer. Actually, His Lordship Justice Mujumdar
might
has the
not-
practice where makes the matter returnable on the date and extends the interim till such date. So it was supposed to be returnable today, Your Lordship, but His Lordship is not sitting. Your Lordship has the urgent determination. If Your Lordship
anyway,
kindly
so let it
publishes
let
the
it be published in
supplementary
the
list today.
supplementary list.
Yes, my
Similar prayer, Your Lordship, as my learned.
The notice served upon.
Yes,
Yes,
my
my
lord, I am
lord.
happy.
lord. Grateful.
Grateful, Your
Yes, at 2 p.m.
Lordship. Your Lordship.
Lordship, may I be permitted to mention one testamentary application, Lordship? This is a substitution application. Service has completed, Lordship. And the matter.
Okay, give the slip.
May I permit to mention one
Grateful,
new
Lordship.
motion application for addition of party? It is a suit for the year 2010 for inclusion in the list, my lord.
for orders item number 1, CC Ishwar
The petitioner.
Sridhar Jiu.
Yes, give the records.
Yes, ma'am.
Record.
This is the trust prepared an application before Lordship, my
I
lord.
think here there are two applications. Which one hearing was done? In which application hearing was done? 7 or GA8?
7, my lord, 7.
Let me see. But so far because I was confused.
No, my lord, 7. Well, in this matter, my lord, valuation has already been effected. Thereafter, my lord, publication has also been made, my lord. Trust paper is the instant.
What was GA8 for? There is another application.
My lord, that is separate application, my lord, filed by another group. Trustee has filed the application, my lord, in respect of another property, my lord.
Oh, right. In GA
7.
that was heard.
Yes, for 7, my lord. This is my application, my lord.
So you are representing the joint receivers.
No, my lord, trust estate, my lord.
You are
There is no receiver, my lord.
representing the trust.
Yes,
estate.
my lord. Trust has preferred this application, my lord. The property is not facing any income, my lord. Fully tenanted, my lord.
On the
Dilapidated.
last occasion, I think the opposite parties also.
No, my lord. No requirement of opposite party, my lord. Only, my lord, confirmation of sale, my lord. Because, my lord, the occupier has, my lord, interested to purchase the property, my lord, considering the proposal of the occupier tenant, my lord. That trust has preferred this application. Trust is trying, my lord, to dispose of the property for the last 8 years, my lord.
Anyway, I'm keeping it next week for orders.
My lord.
Yes, record an order.
My lord, only one
hearing-
thing, my lord. Only one thing, my lord, praying before Lordship, my lord, to consider the special citation of the Honorable Apex Court, my lord, with regard to valuation of the property market value, my lord. Also, my lord, consider.
No, the property is already valued.
Property valued, my lord. Advertisement has been published, my lord. Thereafter, my lord, your lordship will only consider the approval of the sale, my lord. Only, my lord, I am paying before lordship, my lord, to consider the market value, so that for the purpose of registration, my lord, the proposed purchaser can get the scope of relaxation of the stamp duty, my lord. Because it is, my lord, court sale, my lord.
No, that I shall consider.
My lord, so for that reason, my lord, I am submitting this application
Keep that.
by judgment, my lord.
Learned advocate for the applicant. Trust is present.
It is.
Hearing of the matter is concluded. Citation, let the learned advocate has filed a citation of the Honorable Supreme Court. Let it be kept with the record. Fix 14/5/2014. It was 14/5/2025 for orders.
My
যাকে এটা পাঠিয়ে দেবেন
Yes.
এইটাও একটা অর্ডার শিটটা আজকে যে অর্ডারটা হবে না এই অর্ডার শিট সমেত একটু পাঠিয়ে দেন।
Item number 2, my lord, I am appearing for defendant number 1 to 8, my lord.
I am 10 to 12, my lord.
That is whose application is this? GS6?
GSC is, my lord, it is for interlocutory application, my lord, for partition for the property, my lord. Kindly.
You are for?
Defendant number 1 to 8, my lord.
It is 10 to 12.
My lord,
My lord, last occasion, I was not present,
My-
but from the order, it is clear that your lordship heard the matter, my lord, and hearing is complete.
my lord, one of defendant, my lord, I am led by Mr. Lanesir Modan Mohan Rai, my lord. One of the defendant, my lord, Sukumar Das, he is bedridden, my lord. Some instruction needed from him. I am praying for any day after vacation, my lord.
Wrong term matter, my lord, 2021.
Any day, my lord.
24
Um,
matter, my
It's for the plaintiff.
My lord, any day, my lord.
Ma'am.
Bedridden, my lord. Some instruction from
Shantanu Chatterjee, Sambodhan,
needed, my lord, from
Learned advocate Shantanu Chatterjee appearing for the plaintiff.
So last occasion you did not appear.
I could not appear, I
my
missed the
lord,
list.
my lord, give me some times, my lord.
GS7, which application you one time? Which application?
My lord, application 7, my lord,
GS7.
for 7, my lord. And my lord, kindly see the my lord, declaration of the shares of the parties, page 6, my lord.
Yes.
ওদিকে যান।
No, defendant. It appearance.
Your Honor, I am for the petitioner.
Yes.
I am praying for passover.
You are appealing
Mr.
for-
Shiv Shankar Banerjee is in this matter is coming. Your Lordship.
My lord, I
Okay,
am,
pass over.
my lord,
Much-
my lord, I need.
Then let it be not today.
My lord,
Kindly keep it
kindly,
possible.
my lord, kindly keep it in next month, my lord, any day, my lord.
So let the other side advocate come. Let me hear him according to his convenience also. I have to fix a date. So let it be not today.
My Lord, kindly give it passover. My Lord.
Okay, pass over.
Much.
And private limited.
Your Lordship, I am for the petitioner, Your Lordship. Your Lordship, hearing has been concluded. Your Lordship was going
Yes. You are for the petitioner.
petitioner,
plaintiff.
Your Lordship.
Pass over.
তোমরা আছো?
ঝুলটা পাস হয়ে গেছে।
বলুন।
একটু রিচ হয়েছে, সমুদ্র। রিচ হয়েছে।
সেটা
Yes. In the facts and circumstances, this court is of the view that the application for restoration should be allowed. Hence, let there be an order in terms of prayer A of notice of motion dated 21st day of November 2024. Let the suit appear on 9/6/2025.
My lord, the plaintiff has come, my lord.
So, this matter was argued by you on the last occasion.
Yes, yes. I completed my argument, Lordship. I have shown that parties have agreed to the share. So the preliminary degree can be passed, Lordship. And all parties agreed to. So Lordship can,
Your learned friend is seeking for some time anyway.
I mean, Lordship, that is what, why they are seeking time, I tell you.
No, my lord, not just, my lord, any day, my lord, you
How
know.
many times they have sought time, kindly see, because they are in possession of the enter premises. So today they will become unwell to well, and then again they will become unwell. Because they are enjoying the possession and they know, and the share is admitted. So Lordship, what I'm saying,
You know how much time they can linger? At best after
they have
vacation.
taken 2
Just
decades, but
my
then,
At best after vacation.
Any day, my lord, after
no,
vacation, any
Lordship,
day.
kindly keep it just
No,
before
my
vacation.
lord,
Yes.
no, my lord. Bedridden আছে, sir.
Learned advocate for the plaintiff
তুমি শুকো।
and learned advocate. Yes, you are for?
I am for the defendant number 1 to 8.
Substitution of Hellbrook.
Learned advocate for defendant number 1 to 8, and you are for?
10 to 12.
Learned advocate for defendant number 10 to 12 are present. Learned advocate for defendant number 1 to, yes, you are for 1 to 8.
Yes, my lord.
1 to 8, prays for time to obtain necessary instructions. However, in the interest of justice, the adjournment is granted as a last chance. Let this matter appear on
21st, 22nd, on the last day, Lordship, let
No,
them
my
come
lord,
with another plea. They will come with a
any
plea.
day, my lord. After vacation, any
No,
day,
no,
my lord, my lord.
Let them
I am
come with a
keeping it on
plea.
the I am keeping it on the reopening date.
Yes, your Lordship.
Yes, you have any difficulty on the reopening date?
I have no difficulty, but then, all right.
9 or 10, which date shall I keep it?
Whichever convenient to you,
Okay, 9/6/2025
Lordship. I'm
for further hearing and orders.
Lordship.
Grateful. Grateful.
New motions item number 4 in the goods of Bhagirath Murarka.
I'm for the petitioner. So I'm praying for a short passage.
Okay, short passover.
Grateful. Turning.
My lord, I am appearing on behalf of State Bank. Short password.
You are not present, probably.
Lordship,
A report was required to be filed.
I missed my turn.
My lord,
Yes, let me see the record.
short password due to my
Lordship, there is a direction to keep the certified Xerox certified copy to the State Bank. Lordship, it's a voluminous one. We have completed almost 75. Lordship, kindly see. This is the report sent by the concerned officer of the Central Bureau of Investigation. Lordship, 75% of the document has already completed in Xerox. Now, office has been shifted from Nizam Palace to Action Area 3. That's why, for the time being, Xerox.
So when was the order passed?
Lordship, order
The order to the last.
was probably in the month of January 2020. Lordship. And what I am beseeching, kindly direct the State Bank to collect the still date Xerox copies from the office of the Central Bureau of Investigations.
Copies are ready.
Yes, Lordship. 75% are ready, Lordship. This is the report.
So 75% is complete.
Yes, Lordship. This is the report. The communication sent by the Deputy Superintendent of Police, CBI Anti-Corruption Branch, sent me the communication 75. And I beseech you, Lordship, kindly direct the concerned officer of the State Bank to collect these documents from the office.
Kindly direct them to send this, bring this document to the court.
Can he
And
send
then,
it?
kindly,
What is
views-
the order of the court? Let us see.
yes,
The document of 15 almiras. We have completed the Xerox of 13 almiras, just 2 remaining.
and giving some documents, they will say that I have given all the documents.
No, we have not said. We will not say. It is on the record.
No, no. Let them bring those
But
documents.
to supply, they are to supply you the documents.
Madam.
Okay. So if they are telling to collect it, you collect it, you intimate them a date.
Lordship, as per your Lordship's convenience, kindly direct any day. We are ready with the documents.
No, no, you said 75% is complete.
Yes, Lordship, we are ready with them. We are We are hand over the documents to them. We are willing to hand over them. Lordship, any day.
Yes, record an order. Mr. Day, learned advocate for the CBI is present. Learned advocate. You are for State Bank of India. Yes, you are for? Learned advocate for State Bank of India is present. Mr. Day submits that in terms of the order dated 10/12/2024 to supply certified copies of documents indicated in seizure list of application being GA number 37 of 2022. The certified copies are ready for delivery. Mr. Dev further submits that the plaintiff State Bank of India authorities may be requested to collect the certified copies from the office of the CBI. Thus, in the facts and circumstances, this matter stands adjourned till 11/6/2025 for further orders. In the meantime, the plaintiff State Bank of India shall take necessary steps to collect the certified copies of the documents from the office of the CBI upon prior notice.
Let them give the list of, we have asked in this, supply all the
As
documents.
per the court's direction, they will supply you the
They'll
certified
supply
copies.
as indicated in the seizure.
Yes, whatever is there, that they will comply. So you collect it upon prior notice.
If anything remains, you just intimate me. I will hand over.
Okay, let the copy of the letter submitted by Mr. De be kept with the record.
Item number 6, ITC Limited.
This is the defendant's application, not very innocuous prayer. We are issuance of a subpoena upon the concerned officer to produce an official document. I'll tell you, Lordship, this is a defamation suit. I am defending the defamation suit, saying that whatever I have telecast, a program has been telecast. The contents are based on a inspection report conducted by the Office of the Registrar of Companies in terms of the provisions of the Companies
So
Act.
here is GA2 of 2023.
GA2.
Yes, my lord, GA2. So, my lord, my entire defense is based on an official document. So, my lord, to get that document before this court, I am directing a prayer for a subpoena to produce that document. I'm not raising a question that this has to be admitted in evidence right away. At that stage, my learned friend may have his objections, if any. But today, my lord, I do not know how, my lord, like
The opposition is filed to this
yes,
application.
yes, my learned friend.
We are opposing.
My learned friend has filed an opposition, my lord, saying that it is an internal document.
So let
All
me
right.
see the opposition.
Well, we know that it is the internal document. It is based on an inspection of an in due discharge of an official power. So therefore, obviously, that cannot be in my hand. That report. I have not prepared that report.
Yes, which paragraph you have stated?
Well, if your
No,
lordship
I'll tell my
comes
lordship
to
what our defense is.
Yes.
In the written statement, this document was not disclosed. During inspection and discovery, this document was not disclosed. When my witness was coming to the box, then by letter they disclosed this document. They disclosed a photocopy. Now, when we went to take inspection of the photocopy, it was an incomplete document. So now my learned friends have made an application to produce the originals. My lord, first of all, your lordship will have to see whether this document is at all necessary. If their article is based on this document, they would have had to have the complete document. So it's an admission on their part that they did not have this document with them. And yet they are saying that our article is dependent on this inspection report.
First of all, the necessity of
well, that is going
Yes,
to
one is that.
the merit of my defense.
No, one is that.
That document is with me or it was not with me.
Then, my lord, the second objection that we have, my lord, is that my learned friend has to show that this is a public document. Otherwise, how is he entitled to access to this document? He has to show what kind of, it's an internal audit. It was a audit. We also will have to see the final report. The final adjudication is not by this inspection report. It's not an investigation report. It's an internal.
It's an internal inspection report which the registrar gave the company, the registrar of companies. Registrar of companies was to take action or not to take action. They never took action. And 4 months later, this article was published that ITC is fudging its accounts, etc. But that's on merit, my lord.
Yes.
But as far as B, which I believe was being pressed, though in their reply they have said that they
Prayer B, whether it can be allowed.
prayer A was, my learned friend never pressed it initially. We took the point in the affidavit in opposition, but in the reply, his client has said, no, we are pressing both, prayer A and B. Be that as it may, my lord.
But if prayer B is
Prayer
granted,
B will be granted when their time for which evidence comes. They can't disclose, they can't fish out evidence, my lord.
why
Your lordship will hear us on this. We have some
Madam,
cases, etc.
May I explain to your lordship, my lord? Now, your lordship has got an overview of the matter, my lord, from both of us. Now, kindly see, my lord, this is what is my case in the written statement? Just kindly have a look at one paragraph of my written statement.
Which page?
I'll show you, your lordship, my lord, the written statement. And if your lordship kindly sees এখানে একটু written statement একটু তুলে দিন।
Yes.
If your lordship kindly comes to, but there is my advocate from Delhi, my lord, is probably waiting in the lobby to be joined. My lord, kindly direct একটা access দিয়ে দিন।
Oh, is he leading you in this matter?
হ্যাঁ? আচ্ছা যদি আসে একটু দিয়ে দিয়ে দেন।
Is he leading you in this matter?
No, হ্যাঁ হ্যাঁ ঠিক আছে ঠিক। Kindly come to page 13.
Yes.
Towards the middle of the page. The answering defendant have merely reported violations of various provisions of the Companies Act by the plaintiff as mentioned in inspection report of the Deputy Director, Register of Companies, Kolkata. I have not presented my independent view of the case in the program. Whatever there is in a report, it may be a temporary, it may be a interim, it may be final. I am not going into that. I am only to justify, my lord, the defense in a defamation action is, my lord, it is truth, fair comment, justification. So I have to show that whatever view I have given in that program is not my view. It is based on an official inspection report. That is what I have stated here. In that inspection report, it was stated that there are certain violations of the Companies Act, and therefore, I want that report to be there in the records. Today, my lord, kindly consider this. Today, if the matter comes after trial, I will have to prove this defense. Your lordship will have to be satisfied that my defense is based on justification, truth, and fair comment. So, on what basis the court will come to a conclusion that it is not my personal view of the matter? Because it is my specific pleading. Whatever is there in that report, perimeteria I have telecast on the program without any addition or subtraction. So, if that is my defense, my lord, that report has to be there. Your lordship has to ultimately compare that report and what
that is your bone of contention
entire
in the written
case,
statement.
Entire case in my written statement. And kindly see, even for my learned friend is saying that these are defamatory contents. See, it is defamatory if it is personal content, if it is a personal assessment which I have telecast. So, my lord, therefore, it is for effective. Now, my lord, next point which my learned friend is saying that it is a document which I did not disclose. I have specifically referred to maybe in that part where we say documents relied upon or documents annexed to, this document is not mentioned. Precisely because I did not have the original. How will I say that I am relying upon that document? The moment I rely upon that document, I will have to produce it. But I only have a copy of it, which later transpired that it is not a complete set. So I was not in a position to disclose it along with the written statement. But there is a remedy for it. It is not, my lord, a person who relies upon a third-party document who does not have custody or possession of the document. Law does not say that you are without remedy. You will not be in a position to establish your defense. So that is the specific prayer which I am making in terms of the provisions of law. Document is suppose, my lord, the document emanated from my learned friend. I could have given him a notice to produce. If it is emanating from a third party, I still can issue a subpoena upon the third party to produce that document. So that is what I am seeking here. And today what my learned friend is saying that it is a internal document. These objections, I am not taking it away from him. These objections he still can raise, if at all it is permissible, at the time when the document I will try to mark it as an exhibit. Today that stage has not come. Admissibility of the document, relevancy of the document, this stage has not come. This stage will come at a later stage once the document is first placed on record. Mere placing a document on record automatically does not mean that it has become an exhibit or it has been admitted in evidence. That stage we will argue.
When you relied upon a document to make some publication,
I did not have a original copy of it.
but you had a copy of the
Yeah, I had
document,
a copy of it.
because the moment you want to rely upon
Yes,
the
yes,
document,
otherwise how will I say that this provision has been violated, that provision has been violated?
you have also stated the source of obtaining that copy.
No, that I have not stated.
You have not stated the source of obtaining the copy.
For kindly see,
Anyway, that is
yes,
with regard to
that is on merit. That is on merit. But that opportunity I must have to show that it is based on an official document. I did not have, it is a case where I did not have the document in my possession. I say that entire document was not in my possession and custody. Even if I had, then also I would have to get it from the original, from that author or the originator. Because I cannot in this case lead secondary evidence for this also. Suppose I simply had a copy, maybe in that case I had a complete copy also. Even if I had given it for inspection, they would have objected to this, because I will not be able to produce the original to them. Today, this problem has arisen at an earlier stage because I had an incomplete copy. But this prayer would have been made even if I had the complete copy also. So it does not make any difference that today I am only having an incomplete copy. So therefore, my only submission is to this extent, my lord. Kindly do not close my right. It cannot be closed for the document to be brought on record. Whether I can succeed in having it admitted in evidence, let us keep it for the next stage. Let my learned friend reserve all his arguments with regard to that. He will take inspection of that document. He will be able to, my lord, and now, my lord, why I have brought it immediately, not at my stage of my evidence, because today, if the document comes on record also, I will not take, I can put it, confront it to his witness. Suppose his witness action was over. My witness was about to come. At that stage, I had asked for this production. Then obviously the objection would be taken that this document cannot come behind the back of my witness. So therefore, taking all precautions, my lord, I have come at this opportune moment.
Now the stage is the evidence of plaintiff.
About to start.
About to start.
About to start. Not yet started. And my lord, kindly see, And once, my lord, the issues have also been framed with regard to this. Kindly come to page 20 of my application. 18. But kindly come to page 18. Order dated September 8, 2023 of my GA.
Page 18.
18.
Yes.
September 8, 2023. Counsel for the plaintiff.
Which paragraph you are reading? Oh, this is your written statement.
No.
Application.
Application page 18.
Yes.
This is the order dated September 8. Kindly see, counsel of the plaintiff has filed admission and denial of documents disclosed by the defendant. Let the same be kept with the record. Counsel for the defendant submit the defendants have also prepared affidavit of admission and denial, and it is under affirmation. Next, counsel for defendants further submits that they have disclosed another additional document and served the copy to the learned counsel for the plaintiff. This is that document. Plaintiff is liberty to take inspection of the additional document disclosed by the defendant. So this they did not take inspection because that one page was missing. Now I will kindly see next page, the issues which are there. Issue number 2, kindly see. 2 and 3. It is at page 20.
Page 20. Yes.
Issue number 2. Were the statements made in the news program defamatory in nature as alleged in the plaint? Is the defendant entitled to take defense of fair comment and justification as alleged in the written statement? So therefore, my defense is dependent upon the contents of this document. If I don't get it, I'm not successful in admitting it in evidence, that is a different thing. But today I cannot be shut out at the first instance from the document coming in. This is my respectful submission, my lord. But this is also not a procedure which is unknown to law. Lordship will kindly take Order 16, Rule 6. Non-commercial.
22.
চলে যাও তুমি বলো না without prejudice document আসুন।
If my learned friend finishes today, if I am excused, man, there's some third call has happened in the division bench.
So you want to do it on the next day, submit on the next day.
I'll just finish in 2 minutes. My learned friend can
submit.
Because he is to
on the next week, whatever.
Yes, next week, anytime. But only thing is that what my learned friend submitted, if he records that, I will, without prejudice, I won't mind. He said that he has said in the article identical, not one word more, not one word less than what is there. Now, he said that.
Yes,
now, if that is the case, if that is the defense, that not one word more, our defense is.
We have to, at this stage, I have to confine myself with regard to this document production.
My learned friend is saying this document is necessary because verbatim he has not one word more, not one word less, he has said in his article. Then he's going to, if he, I'm not holding him to it just today, but I'm putting him on notice. He said that because last time he said that he's not pressing Prairie, his client is.
You can come with the short notes also.
No, I'll come with the note. The main thing is, my lord, in the affidavit of documents and in the written statement, we are to mention these are the documents we are relying on. These are the documents in our possession. These are not in our possession. They don't rely on it. They write nil. And my learned friend is saying here from now that he always had a photocopy of that document.
It's a procedural.
No, they have to disclose.
I have missed out. I accept
that. Then thereafter affidavit again. So no condonation. That's our first ground that there is no sufficient cause for them to produce a document at the time at this stage. That's the first thing. It's not a commercial suit, I understand. It'll be possible for him. And then why should the court help him do it? If he has to do a subpoena, he could have done a subpoena. There's no court order is required for that. So the main objection is the court can't do it. But as far as these submissions that are being made, if it's recorded, our claim is that even if this document is shown, the language used in the program. No, my learned friend is saying, he's conceding that not one word more. If he puts his case so high when he's arguing a simple matter, then he has to be held to it. Then I'll agree. I'll say that very well. If he's saying, we'll see the report. If it's the same language, I have nothing to say. If it's been held that we are fudging accounts, we are falsifying, they put it up on Prime News, and it's a company's reputation was at stake at that time. Now they've stopped. They stopped immediately after we wrote letter to them. Now it's the question of an apology or damages. Or withdrawal of that
So
statement.
damages will also arise if my learned friend can establish that I have written.
His defense is justification.
Yes, his defense is justification, but the submission that's being made is that this document is so vital that whatever is written there, they have said.
That would be my attempt.
Now, then temper your submissions. That's all I'm saying. Mano will keep it next week. Mano,
No,
let him come back.
Yes.
And the other point is my learned friend should show under what provision. Now he's showing that the court will help him get this document.
That would be better. On the next week, both of you come with short notes of arguments. I think the matter will expedite.
Very well.
Note, my lord, on reopening. There's no time to write.
It's a one page, my lord.
Next
week, you give a suitable date so that both of you can come with the notes.
Yeah, we'll write a note. Next Tuesday, next Wednesday, whichever day. Follow. It's Monday's a holiday.
Monday is a holiday.
Wednesday, there'll be a lot of rush that time. Thursday. Thursday, the next Thursday. Let it be on Thursday. If we can do it, we'll try.
Thursday in the chamber.
Chamber is only Tuesday na Thursday.
Will be taken up. Or at 2 p.m.
Oh. Any day.
Yes.
My lord, may I be excused? I'm sorry to have stored.
So, have you completed or do you want to submit something more?
Well, let him submit on the next day. We'll bring our notes.
Next day, my lord, I'll submit that note and complete.
Yes.
Learned counsels for the parties.
May I be excused?
Mr. Sen, learned advocate for the petitioner defendant.
Wednesday fixed
submits on GA2 of 2023. However, as the submission is not complete, the matter stands adjourned till 14/5. That is next coming Wednesday. 14/5/2020.
Will your lordship keep it at 2 p.m.?
Let it, because I don't know whether 2 p.m. have other matters or not. Let it remain in the 14/5/2000, because that is not a chamber day.
No.
14/5/2025 in its usual position. Learned advocates are requested to come with short notes of arguments.
Lordship, this matter.
I'm one of the applicant, Milord, in this.
Item 7.
Lordship, this was appeared before your Lordship, Milord, on 5th May, and your Lordship, Milord, are pleased to.
It is wrongly appearing today. The matter has already been returnable on 10th June, Lord.
Let me see the order.
That is the order of 5th May, Lordship.
Yes, 6. Yes. In terms of order dated 5th May 2025, this matter is due to appear on 10th June 2025. Let this matter appear on the scheduled date. এই কাগজটা একটু দিয়ে দিন।
Appearance এখানে আছে। Item number 8, Annapurna Commercial Company Limited.
I appeal the defendant
On the last occasion, Mr. Tiwari had submitted before your lordship, there were 3 applications, GA 2, 3 and 4. 2 was the injunction, interlocutory application preferred by my learned friends. 3 was my application for 3 was my application for dismissal of the suit. 4 was their application for extension of time for filing or for lodging their summons with the learned sheriff's office. Lordship, today was fixed for Mr.
Anyway, let it be passed over.
Item number 9, Annapurna.
Lordship, 9 and 10, it's together.
8, 9 and 10 passed
8,
over.
9 and 10 is together.
8, 9, 10. Item number 11, Anil Kumar Patodia.
I'm appearing on behalf of the plaintiff, my lords.
So whose application is this? GA16?
GA16
is my application.
My learned friend's application.
GA16. Affidavits are complete.
Yes, my lords.
GA16 affidavits are complete, my lord.
Mr. had made submission, my lords, on the last occasion, my lords, and we were, my lords,
Millet, I appear for respondent number Millet 2 to 4. Millet, my expunging applications are Millet listed today.
My expunging
That
application is also there.
That is Millet GA number 22 to 24.
my application, my lords, has been heard, my lords.
That has to be Millet heard and disposed of first, and it was also observed by Justice Krishna Rao while taking up this matter that Millet expungings to be done prior.
My lords, may I indicate this, my lords?
Let the expunging be taken up first, Millet. Because no point hearing the injunction because Millet, they have waited for 2.5 years.
Any manner. So I will show that, my lords, from the application itself. Let's kindly take up GA16.
The problem is the person applicant in GA16 is selected for protection of property.
Yes.
His intention. He is the properties. He is saying in respect to PCD properties.
21st March
You have GA16.
GA16
Affidavits are complete.
my lord.
It is the
My learned friends are today stating.
No, what are your prayers?
Have a look at the prayers, so selective it is.
But my application may move it.
Yes,
Because it can't be that my learned friend is moving my application.
No, there are several applications. It's not like it is only his application which is there.
Let the expunging applications be taken up first, Millet. These are Millet protocol, Millet of taking up the some basis.
And for what? Expunging the name of
Millet for the deleting the name. Mr. Sen has 1 application. I have 4 applications. I will expunging. Millet, those are in terms of
expunging the name on what ground?
Of the companies, of the corporate entities. Millet, corporate entities cannot be a part of Millet partition suit.
What has
those are Millet companies.
Just minutes. Can I be permitted for 5 minutes to make my submission?
Structure.
They have waited for 2.5 years, 3 years.
Urgent.
Okay. Very not urgent.
Very urgent.
Well, not at all. Not at all. Well, 13 years later they are coming.
Because I have had this GA16.
Do not concern Millet.
Yes, Mr. Bose, please submit.
Chalo, bolo.
Lord, I have an application for injunction.
Yes, you have submitted on the last occasion.
We are in 25 for an injunction. But you can understand, 2013 suit is not a 2013 suit. We are in 25.
But nobody wants the judge to understand. This is the problem in this matter.
22, this application was taken out.
Correct.
So after 9 years.
So at that point of time, was there any interim order?
Well, there was
there was no interim order.
There was. Was an interim order in relation to one of the companies. After that, my lord, an appeal, my lord, there was an application for vacating that interim order. That was dismissed. From that, an appeal was preferred. That appeal has also been dismissed. Much subsequently, now one of the defendants has come up with an application for interim orders. Well, first,
to some of the properties.
Correct. Subsequent.
Some of the properties, chosen properties.
Yes, chosen.
What has to be shown now? What is the cause of action today? Why suddenly after 7 years?
Let me show it. My application.
All properties.
Why are they moving my application? I can't understand.
Because you have not moved for last 3 years.
Now he also has to say something.
Definitely.
So you
have applications for deletion.
My affidavits may be taken on record. My affidavits in GA.
The affidavits are complete in the deletion application.
5,
GA 23,
23, 20. 27.
Now GS 16 is any application.
Already
Position and
complete.
already
That is
complete.
Other that will be taken on record, my lord.
Yes, please.
My lord, kindly come to page 69 of the application. My lord, this is
Yes.
an application by D by some of the defendants, which is defendant number 5 to 9
Page 69.
in the suit. Page 69. My lord, kindly come to page 69.
Yes, 69.
Yes. kindly. Yes. Now, my lord, here are the prayers. Now, I will restrict my submissions today to my prayers for injunction, which is prayer A and B.
My lord, this is being heard at the final stage. Let it be heard finally, my lord.
Let
If
this
in a peaceful
injunction cannot be heard because he has to cross the barrier of NCLT.
How will I complete, my lord? Your lordship can understand. One is on the virtual platform, then the
you
plain.
submit whatever is
Kindly take, my lord, A and B. Your lordship will see prayer A and B is restricted to properties. May I just allow me to place the prayer? It says injunction restraining the plaintiffs and the defendant number 1 to 4 and 12 to 17 and or each of them, their main agent servants from dealing, disposing of, encumbering and creating any third party right, title and interest or selling, transferring any properties or assets of defendant number 36, 37, 46, 47, 48 and 56.
Yes.
And my lord, your lordship will see prayer B is also restricted to properties and assets of defendant number 36 to, so some of the defendants.
This is prayer C.
Prayer B.
Prayer B.
A, B, and then I ask for receiver in respect also in respect of the assets and properties of the same defendant. Now, my lord, your lordship will kindly see, my lord, apropos defendant number 36 and the other defendants as mentioned in prayer A, my lord, your lordship will kindly take what is the case that I have made out. My lord, kindly come to page 44 of my application, which is, and I'll draw your lordship's attention to para 51.
Yes.
At the bottom of page 44, detailed list of the properties held by 36, 37 and 46. So these are three of the defendants in respect of whose properties I seek. Now, my lord, the first property.
Defendants have contested your application.
Yes.
Representing? Who is representing?
36, 37 and 46.
Any opposition filed by these defendants?
36, 37 and 46.
They have not filed opposition.
They have, I'll show you. Yes, of course. No, they have not filed. They have not filed.
See whether they have been served.
36, 37 and 46.
Kindly check whether the service is complete on all these defendants.
You submit thereafter, you have to.
Yes, yes. Everybody has been served. I'll tell you, Lordship, what has happened. There are two oppositions. One opposition is by 16 and 35, and the other opposition is by 2, 47, 48, and 56. There, I think today Mr. Mukherjee handed over opposition on behalf of the plaintiff.
I am for the my opposition has already been there. My oppositions in GA 25, 23, 27 and 26. These are the ones I want to file.
The specific question is whether
16.
the injunction which he is seeking against the defendants, whether they have filed any opposition
Correct.
to this.
They haven't. They haven't.
Whether they've been served.
They have been served or not? Then
yes. Do you know?
Of course, they have been served. Of course, of course. Affidavit of service is a part of the record.
Okay, okay. See if the affidavit and service.
Well, how is he concerned? He is not representing 35, 36, 36, 37. No, my lord, let me understand. It's a civil suit, partition suit. Now, if the defendants against whom I seek the order of injunction is not opposing, I am not been able to understand and perceive the fact that how are the other defendants concerned.
Let my learned friend first submit, then I will reply.
Represented in the suit.
My lord, defend number 36, 37, these are asset holding companies. If your lordship sees the plaint, my lord, it goes on the basis that there are 5 branches of this family called Patodia family.
Absolutely.
Some of the individuals, they are all made parties, and the defendants, companies which are being, their assets being treated as assets of the family, that's why they've been made a party, because these are all from the joint corpus and they have to be treated as joint family, and it's partition of those joint family assets which are in the name of companies that is being sought.
So by
So the
virtue of that,
right,
they have been made a party.
yeah, that's on that person.
Although prayer is made to expunge them.
Yes, my lord.
No,
Some
not
of them
these.
have filed.
Some of them have filed. Some of them have filed.
So like my learned friend here is accepting the fact that these companies are in fact joint family companies.
I am.
Therefore, he's seeking an injunction on them.
I am.
Some of them are seeking expunging, saying that they are not joint family, they should be removed away. And I am the plaintiff, it is my case that they are all joint family.
Correct.
But whether injunction is necessary, that is a different matter altogether.
And my lord, these properties in respect of which I seek the injunction, they form a part of the plaint. That is the joint family properties. And none of the defendants have disputed the fact that these form the part of the joint family assets. So my lord, injunction is a matter of course. But despite that, I'll satisfy your lordship, my lord, the events, my lord, now it has become imperative that certain orders be passed because they are trying to deal with the properties. I'll show your lordship, my lord, kindly come back to page 44, para 51. There are 2 properties, 2 valuable properties, which are held in the name of these 3 defendant companies. My lord, one your lordship will find at Short Street, 10 kathas of land, which is at Short Street. And thereafter, your lordship will find the value of that property, according to us, is 30 crores. And the next page, 45, which is the second property, is at Moira Street. Well, this is in the name of defendant number 46. Now, your lordship will find, allow me to first show your lordship that this properties actually forms part of the plaint or not. Now, my lord, your lordship will kindly take page 109 of this application. Why page 109? Lord, kindly take para 18. This is a part of the plaint. I'm showing your lordship. Lord. This is page para 18 at page 109, which is a part of the plaint. It says Brickworth Builders and Uniworth Laminates, the defendant number 36 and 37 herein, own a plot of land of 10 kathas, approximately an old structures at Short Street, within the jurisdiction of this honorable, the said company of family companies. This is one. Then, my lord, kindly take page 164. My lord, this your lordship will find in volume 2. This is a part of the list of properties which, according to the plaintiff, is a part of the joint family properties. Volume 2. Great. But it starts at page 164. Yes. Well, this is at 164. Your lordship will find detail of immovable properties held by the Patodia family. Then, my lord, kindly turn to page 165 and take serial number 20 and 21. Your lordship will find Moira Street and Short Street. 20 and 21.
What is referred to in your application?
Absolutely. These are the 2 properties. So, my lord, I am not traveling beyond the assets mentioned in the plaint and which forms a part of the partition suit and the list of joint family properties mentioned by the plaintiff in the partition suit. Now, my lord, your lordship will find I was in control. My lord, if your lordship will kindly turn to para 63. These 3 asset holding company, 63. In fact, it starts from para 60. My lord, what had happened, I'll tell you, Lordship. My lord, different family members, as Mr. Mukherjee has rightly pointed out, well, there are 5 groups of Patodia family. Now, my lord, plaintiff 1 and 2 forms one branch, defendant number 1 to 4 second branch. Similarly, my lord, I fall into one branch, which is defendant number 5 to 9. Now, my lord, these are asset holding companies. Now, my lord, these 3 companies, which is mentioned, my lord, here, defendant number 36, 37, and 46. My lord, I was a shareholder and I was also a part of the board of directors. Now, what has happened is I continue to be a shareholder, but I was removed from this company by way of board of directors. My lord, which I have challenged in this petition as well, that the board meeting held, I did not have notice of the board meeting despite being a director.
Even if you have challenged that, that relief can't be granted in this partition suit.
Now, my lord, what has happened is this exercise of removing me was for the purpose of dealing with the property. Because since if I am on the board, then they have to take my consent to deal with the property. So I am removed from the board. New directors initially taken as additional directors. Thereafter, those additional directors hold a general meeting and confirm the directorship. So I have challenged all that and I allege that all of that is illegal. Now, my lord, what is the purpose of this action? The very purpose of this is to ensure that I do not form part of the decision-making process. And these two assets, valuable assets, will be dealt with. So, my lord, this is my apprehension. And, my lord, here, your lordship will see, I have detailed why. My lord, what has happened is, I was a part of the board of these 3 companies. My lord, I am defendant number 7. I was in a board of directors of these 3 companies, which will be evident from the annual return of these 3 companies, which is 36, 37, and 46, which have appended to this application. It is disclosed by me. Now, if your lordship will see, why we say at para 59, I have given the reasons why I say that my removal is bad. Because they say there was a board meeting held on 3rd of December 2021 at para 59, which I say is illegal and void. My lord, I have given the details of that, my lord. Then your lordship will also find at para 61.
Yes.
Well, this is interesting. Defendant number 17, who undertakes the exercise of removing me, he himself resigns.
Para 60.
Para 61.
61.
Well, I'm just showing the illegality that has been perpetrated in order to remove me and deal with the assets. So this is the reason it is now become imperative that these assets should be protected. No further transfer, no alienation till the disposal of the suit. Now, my lord, kindly see para 61. Here I say, from the DIR 12 which has been filed with the Ministry of Corporate Affairs, well, it is evident that defendant number 17 has resigned as a director from these 3 companies from November 23, 2021. And he has himself accepted his resignation. And simultaneously what he does, he accepts his resignation, goes out of the company and appoints defendant number 13, 15, and 16 on the board.
Your relief is directed against defendant number 36,
36, 37, and 46. Where
7, 48, and 56.
First 2 properties are 36, 37, and 46. These are the companies which are the
46, 47, 48.
Yes, that your lordship will find at para 51 at page 44.
You want a restraint against 1 to 4. Yes.
36, 37, and 46.
Yes.
So I was a director. I was removed. Now your lordship will find at para 63, I have stated a general meeting is held on the December 27, 2021 of these 3 companies. Now, my lord, now why the general meeting is bad, my lord, that I have said at para 64 at page 51. No notice without consent of defendant number 7 and 9 who are shareholders. Well, all the details I have given, why we say the general meeting has been held. Now, my lord, your lordship will see all these actions have been taken systematically, engineered for the purpose of dealing with the property. My lord, my apprehension, and I've got sufficient reasons to apprehend that why these actions, because you're attempting to deal with the property. Now, if you don't deal with the property, which admittedly is a family company based property, because these are companies which hold the assets of the company, and this forms a part of the joint family property. So if there is an order restraining these defendants from dealing with transferring or encumbering so that the value of the asset does not diminish, he should not be allowed to mortgage the property. He should not be allowed to induct third party. He should not be allowed to enter into any agreement dealing with the property. This should remain as the joint family property. This is the limited prayer that we seek in this application. Thereafter, your lordship will find well, the other three properties in respect of the other companies, your lordship will find, if your lordship will kindly come back to the prayer, defendant number 47, 48. Now, this your lordship will find is item number 23 at page 165. There is another property which is held by that company. Defendant number 47 and 48. Item number 23 at page 165. Show me 165. Well, this is a very valuable property at Gujarat. Well, this is held and this is held by the defendant number 27, 47.
Page 166.
Yes, 165.
165 serial number for
Serial number 23.
serial number 23.
Yes. 23, your lordship will see I stand corrected, it's a residential bungalow at Jubilee Hills, Hyderabad. Here your lordship will find in the next column Ganesh Nirman and Unique Nirman. These two are defendant number 47 and 48.
Yes.
Now, my lord, I have also reasons to apprehend that these two defendants, which are also holding this joint family property, well, they have also taking steps to deal with this property, which is, my lord, which is what? It's a residential bungalow of the family. So, my lord, your lordship will see Moira Street, Short Street, these two properties in Calcutta and this property in Hyderabad. All these properties, valuable properties, admittedly joint family property. None of the defendants have never alleged that this does not form a joint family property, and there are no applications by at least these defendants at any time in the suit saying that these are not joint family properties. So, my lord, it is imperative that these properties should be maintained in the manner in which they are. There cannot be any change in the structure of these companies, number one, and number two, the assets which are held in the name of the company, they should remain, there should be a status quo on the assets, which are these three properties, valuable properties. No transfer, alienation, encumbrance, or even, my lord, no third party interest should be created, allowed to be created on these properties. Now, my lord, now if your lordship will kindly see, I have made out the case so far as dealing with these assets are concerned. Well, from paragraph, I've started from paragraph 51 onwards, and thereafter I have pleaded from paragraph 83 onwards why these injunctions are necessary so far as these two properties are concerned.
Page 51.
Yes, onwards. The entirety, the remaining part of the application deals with why it is necessary in the interest of all members of the family, and I represent one branch, that these properties should not be dealt with. Now, my lord, there are other prayers that we seek in the application. Well, they can be dealt with at a later stage, but this is become imperative. Nobody should be allowed to deal with the property till the disposal of the suit. Well, whether now I will get the other prayers or not, that can be decided at a later stage, because I have sought for declaration that these board resolutions and the general meetings and the steps taken by them should be.
A and B.
Yes, my lord. I am restricting my submission today to A and B, because this has now become emergent. If you actually deal with this property, then, my lord, what will happen? My lord, this will go out of the hodgepodge of the joint family. It forms, admittedly, it forms a part of the hodgepodge of the joint family, and three valuable properties, which is there mentioned in the schedule to the plaint, which is page 164 onwards. Now, my lord, if your lordship will take, interestingly, who opposes this application? My lord, if your lordship will take.
So let the parties who are opposing this application, let them submit.
Very well. Now, my lord, your lordship will kindly make a note. The defendants against whom I seek the injunction.
The properties which you, the company's property.
The company's
you seek injunction.
Correct.
And the defendants against whom you seek injunction.
Right. So those defendants at best who say that these are all family members. Now, I am a shareholder. There are certain other defendants, other family members who are also shareholders. So these are basically family companies, through interlocking of shares. These companies, all private companies, these are all closely held family companies of the Patodias. And the assets are held in the name of the companies. If your lordship breaks it down, your lordship will see each company and the shareholding in each company is spread across the 5 branches of the family. My lord, in some companies, I have shares. In some company, they have shares. So some of these companies also hold shares in the other companies. So this interlocking of shares is an accepted position. So how does it matter? When was this paid?
Yes.
So, well, there is no, apart from the fact that I have come late, that this application has been filed in a 2013 suit in the year 2022. Apart from this fact, there is no effective opposition to my prayer for injunction in respect of these 3 properties. And my lord, so far as delay is concerned, my lord, delay cannot defeat the courts of justice. If today I feel during the pendency of the suit that a situation has arisen which gives rise to a cause of action for filing an interlocutory application, and if I am able to prove that prima facie these properties which are joint family property, well, in a commercial suit, well, the test is different. Well, in a partition suit, well, injunction is a matter of course in respect of joint family properties. Now, once the parties do not dispute the fact that these are joint family properties. In my respectful submission, my lord, the prima facie test stands satisfied, and the balance of convenience is in favor of passing orders that the joint family property should be protected till a preliminary decree is passed or the final decree is passed subsequently. So, my lord, the examination and the consideration in a partition suit, my lord, is entirely different from a commercial litigation, where, my lord, one has to see the conduct, the additional part, the conduct, whether the balance of convenience is in favor of passing orders or in rejecting, will it cause more prejudice to the parties if an injunction is granted. These are the examination. But in a joint family property, when the parties accept, I do not wish to repeat, my lord, your lordship has seen, it forms a part of the joint family property. So how would anybody, my lord, if these assets are actually dealt with, then, my lord, it will prejudice the interest of all parties at large, whether it is my group, their group, whichever group. And it is also not in dispute that these defendants are actually asset holding companies, and that the assets are held through these companies, so they become joint family property. That is the case made out by the plaintiff.
It is a plaintiff's case.
It is their case. So I am
Accepted by
in aid of the plaintiff's case. I say today, since, my lord, as your lordship, the transposition of parties are permissible in a partition suit.
Yes.
So whether I'm a defendant or not, I have a share. So they have admitted that I have 1/5 share in the entire assets. So effectively, my lord, if there is a partition, I will get 1/5 of whatever is the assets. And these have been made a part of the asset of the joint family property.
Share of which defendants you have?
No, I am a set of defendants,
Yes.
and I have 1/5 share.
Each.
No, 1/5 jointly.
1/5 shares by these defendants.
By these defendants who have applied before your lordship, who are the petitioners. And, my lord, that is there. If your lordship will see once, if I trouble your lordship once, page 150. Page 150, the prayer starts at page 149.
Page 150.
Yes, my lord, kindly take 149 first, volume 1.
Sorry.
149. Prayer D.
Plaintiff.
Which is a part of the plaint. Prayer D, bottom of page 149. Declaration of the shares of the parties concerned in the joint estate comprising the immovable properties mentioned in Annexure A, which I just placed before your lordship at page 164, as also the companies, firms mentioned in Schedule D, which forms these four companies are part of that. Their assets and properties as follows. My lord, plaintiff number 1, defendant number 1, I am defendant number 5, 1/5. So this is my entitlement in terms of the plaint filed by the plaintiffs. Then, my lord, kindly take E. Declaration that the defendant number 22 to 57, which includes the defendants against whom I seek the injunction, are family concerns and the extension of the Patodia family, both for the purpose of carrying on business as well as for the purpose of holding joint family assets and properties.
Yes.
So after this, how can anybody oppose a prayer when one set of defendants come and say that somebody is trying to dispose of the properties? No, these are my respectful submissions over prayer A and B.
So
Who is opposing this application?
I am for the plaintiff.
Yes.
My lord, firstly, I would want to know whether defendant number 17 would want to submit first or not, because the primary allegation is against defendant number 17. If your lordship sees my learned friend's petition,
It is.
which my learned friend has made out, my lord, paragraph 61.
Page 69, that is restraint order sought against 1 to 4.
Yes, my lord.
And 12 to 17.
But the allegation is made in para 61, if your lordship takes.
Mr.
Primarily
Mukherjee is
against
correct that
defendant
defendant number 17 is the one who resigned and inducted the other defendants, and he removed me as well.
Page 61.
Para 61. My learned friend's case, my lord, in a nutshell, is that he was a director in a company, in 3 companies. The defendant number 17 caused board meetings to be held, removed him, added other persons as directors. And all this has been designed with a view to take control of these 3 defendant companies so as to deal with the assets of the companies.
This is the basis of the apprehension.
His basis is that in 3 companies, he was a director, he has been removed, and after his removal, other persons have been added in. And now this has been done so that these companies' assets can be sold. This is his nutshell. So he has to show, which he has not, unfortunately, that he has been wrongly removed as a director. New persons have been wrongly added. And further and most importantly, that assets of the company are in fact being dealt with. These are the 3 ingredients he ought to have shown. Well, so just first, if defendant number 17 is to reply, I would rather, my lord, answer after the defendant number 17. If there's nobody, then I'll make my submission, my lord.
I will deal with it.
My lord will kindly take the petition. My first point, my lord, is this defendant has not come with clean hands. Has not come in with clean hands. My lord will kindly, first your lordship, if your lordship takes the cause title. There are 5 branches of the Patodia family. Anil Kumar Patodia is one of the kartas of one of the branch, plaintiff number 1. The defendant number 1, Sunil Kumar Patodia, is another branch. Defendant number 5, Pawan Kumar Patodia, is another branch. That's my learned friend's client.
Item, that is defendant number 5.
Defendant number 5. My learned friend is representing defendant number 5. That's the 3rd branch. Well, defendant number 12, Sushil Kumar Patodia, is the 4th branch, and Sudhir Kumar Patodia, defendant number 15, is the 5th branch.
So all Patodias are
Patodias,
the family.
5 branches. So the plaint, my lord, proceeds that these 5 branches are there, and the other defendants, my lord, if your lordship sees up to defendant number 21, they are all children or relatives arising from these 5 branches. They are all part of these 5 branches.
That is a Mitakshara family.
Mitakshara family, my lord. So there's sons, there is wives, daughter-in-laws, daughters, all of them are there, my lord. If your lordship notes, my lord, so far as the defendant number 5 is concerned, defendant number 6, Daya Patodia, is the defendant number 5's wife. I'll tell your lordship why I'm pointing this out. Your lordship will kindly now take paragraph 37 of the petition. Well, the argument first I'm making is that the defendant number 5 has not come with clean hands for that purpose. If your lordship sees, the applicant's 37. Applicant, my lord, is defendant number 5. There are not multiple, there is one. The applicant states that defendant number 35
owned a residential flat 6A Ironside Road. The said company was incorporated on 14 September 95 and its valid shareholders are set out herein below. And my lord, if your lordship sees, there are 10 shareholders and the names of the shareholders are given. The serial number 5 is Daya Patodia, 10,000 shares.
Yes.
Serial number 5. Daya Patodia, 10,000 shares. Then if your lordship takes para 38, the petitioner states that the defend number 5 family group at all material times held 30,000 equity shares. Out of that 30,000, 10,000 is Daya Patodia. Of and in defend number 35. However, defend number 16 and 17 have purportedly, in collusion and connivance with the plaintiff number 1 group, defend number 12 group, and defend number 15 group, that is the other 4 groups. This is the case which is made out.
This is your grounds in the objection opposition.
Yes, my lord, it is all there. I will show. I am showing that this is the petition.
Yes.
This is the petition case. I will show my opposition also. But let's see, my lord, what they have said. The defend number 16, 17 have purportedly, in collusion and connivance with plaintiff group, defend number 12 group, and defend number 15 group, struck off the names of the defend number 5 group as shareholder and in defend number 35 company. Annual returns is shown. So then what does he do, my lord? If your lordship sees, again, the shareholders is shown and Daya Patodia, which is page 38, serial number 5, is shown as 0 from 10,000.
Para 38 is denied by you.
Yes, my lord, I will show denied and a false case made out. Now, my lord, if your lordship sees para 39, why the case is made out particularly against me here. The petitioners state that majority of the original share certificates of the family companies being 25, 27, 29 to 37, including 35, 39, 44, 46 are in possession of the plaintiff number 1 and the plaintiff defend number 1. So he says, what is the case he's made out, my lord? A copy of the plaintiff's letter submitted to the conciliators is annexed here too. In addition, the plaintiff, through his daughter, is in possession of these certificates. It is tried to mention the plaintiff number 1 has denied possession. Para 40.
May I just take your lordships kindly, but let my learned friend say I will make my submission on the next date.
So, my lord, may I just, before the conciliator part, before the matter came to court, my lord, the parties had all gone to the conciliation, for a conciliation. This was in the year 2007.
That is prior to the partition suit.
Prior to the partition suit be filed. The reason why the partition suit actually came on to being filed is because there was a conciliation agreement also, by which the parties had agreed which companies would be allotted to which group. But there was a breach of that conciliation agreement in relation to one company by this defend number 5. That is why the suit was filed. But now, my lord, what is the case being made out? Case being made out here is that in one of these defendant companies, defend number 35, the share certificates were all with the defend number, were with the plaintiff and the defend number 1. And the plaintiff and the defend number 1, they have manipulated the share certificates, and that is how the shares of the plaintiff group of the defend number 5 group from 30,000 has become 0. That is why I was showing, my lord, Daya Patodia's name is there. Daya Patodia, who's, my lord, the defend number 5's wife and part of the group, held 10,000 shares. My lord, if your lordship takes para 40.
Also one of the
defendant. Yes, defend number 6. My lord, para 40. Para 40. Due to the aforesaid reason, the petitioner apprehends that the plaintiff number 1 has parted with and or manipulated all share certificates which he had in control of the defend number so-and-so. Therefore, the plaintiffs pray for a direction upon the plaintiff number 1 to forthwith submit all original share certificates and records as per Annexure G, besides documents so-and-so. A similar action. So, my lord, his case is that I have manipulated shares, 10,000 shares of defend number 35, which was held in the name of Daya Patodia, has been manipulated by me. from these paragraphs. Well, kindly now, my lord, take my affidavit in opposition.
Yes, affidavit in opposition
Affidavit in opposition
of the plaintiff.
Of the plaintiff, my lord. Volume 1, if your lordship takes. আমার 3-4 ভলিউম আছে। হ্যাঁ, পেজ 44 দেখেন।
Yes.
My lord, your lordship will just once before your lordship sees this page, mark at page para 39 of the petition. My lord, if your lordship sees what is the exact case made out. Petitioner states that majority of the original share certificates of family companies 25, 27, 29, 37, 39, 44, 46 are in possession of plaintiff number 1 and defendant number 1.
Yes.
Paragraph 39.
So how have you dealt with this?
My lord, kindly seize para 44, page 44.
Page 44.
Page 44. I'll show my pleading also, but let's see the document.
Yes.
My lord, this is a complaint lodged by Daya Patodia, the defendant number 6, on 17th October 2015, much after the suit was filed also. What does she write? I have the following share
So
certificate.
page 44, running page 44.
Yes, my lord, of the affidavit in opposition.
Yes.
My lord, it should be an affidavit of Anil Kumar Patodia. Anil Kumar Patodia.
Oh, right. This is by 12, 15 and 17. Yes, plaintiff's opposition. Okay. Okay. Yes.
Mala, this is a complaint by Daya Patodia with the police in charge, Shakespeare Sharoni Police Station, filed on 17th October 2015, much after the suit was filed. What does she write? I have the following share certificate of 3 companies in my name, which are misplaced and not traceable from my residence at 3 Moira Street on 16th October and then from 16th October 2015. The details of the share certificates. Ashoka Farm is defendant number 39. Brickworth is defendant number 36. Uniworth is defendant number 37. Look at the absolute false statement made in the petition. Shares she held with her at all point of times. She has misplaced some of the shares. She has filed FIR and now she makes out a case that they are in my possession. And they don't even disclose this document.
Yes.
And now, my your lordship will see prayer D. My learned friend was not pressing this prayer because of this reason. Prayer D, page 71. He seeks a direction on me to submit all these original share certificates, my lord, from the before this honorable court. Prayer D, a direction upon the plaintiff number 1 to forthwith submit all original share certificates and records of the family companies and properties in his possession as per Annexure G. And Annexure G includes these very shares also.
There are no allegation of theft, only
misplaced.
No
Misplaced and are not traceable.
No allegations against the
plaintiff. Nothing against the plaintiff.
Had it been some allegations against the plaintiff,
absolutely, my
that
lord,
would have been considered.
And most importantly, I'll tell you, lordship, why this has happened. In 2007, when the conciliation was happening, at that point of time, all the shares of all the family members were given to the conciliators. Some shares were given to the plaintiff. Plaintiff subsequently has handed back shares of each respective party to them. including the defend number 5 group. It is unfortunately not recorded in writing. Taking advantage of that, they made this statement in this application, forgetting that they themselves.
Any letter given to you to hand over this?
My lord, nothing. At no point of time.
Because here in this particular complaint, there is no mention.
No mention.
Of theft by you
Nothing.
or whatever it is.
Absolutely not. And they suppressed this document altogether. This paragraph I was showing only for the purpose of showing that this petitioner, that is the defend number 5, has not come with clean hands. Now, my lord, furthermore, and most importantly, now your lordship will come to paragraph 61, the present cause of action.
Para 61 of your.
My lord, of the petition. My lord, in my application, in my affidavit in opposition, I can show all my pleadings. Yes. But before that, you want to, my lord, should I show the pleadings first?
No, your.
Yes, my lord, my pleadings. Your lordship will kindly take paragraph 30 at page 20.
Yes.
With reference to para 41, 42 of the said application, it is denied that any order of injunction should be passed as prayed for. It is denied that I was in a position to complicit any action or that I was in possession of the original certificates of various companies after failure of conciliation. In this connection, I state, Daya Patodia, defend number 6, wife of defend number 5, the applicant herein in the year 2015, lodged a FIR stating that she had misplaced certain share certificates which included share certificates of defend number 36, 37, 39. A copy of the letter issued is annexed here to. This clearly shows that defend number 6, who is part of the defend number 5 group, was in possession of the original share scripts and she has misplaced the same. The allegation of the plaintiff number 1 is in possession of such share scripts is absolutely false, and such statement has been made only with the purpose of the present application, and the same is false and false to the knowledge of the defend number 5. I reserve my right to initiate appropriate proceeding against the defend number 5 for making a false and misleading statement. A prayer has also been sought against me pursuant to this allegation. Now, my lord, if your lordship takes the next pleading, next case, which is the present cause of action which my learned friend is seeking, my lord, will kindly take the allegation first made is para 59. Well, para 50, actually, if your lordship takes, well, from paragraph 54 onwards, para 54 onwards. Of the petition, para 54. The petitioner states, well, para 54.
Yes.
The petitioner states that the said defendants 36, 37, 46 were being managed by the petitioner since 2007, and after the conciliation agreement was entered into by the defend number 1, 5, 12, 15 and plaintiff number 1. The composition of the shares between the groups or management of the companies were never changed except what is stated herein before, and further no acts were done to encumber the rights of the shareholders. Now, paragraph 55. The petitioner states that the petitioner in and around January 10, 2022 was shocked and surprised to find that the defend number 17 has appointed plaintiffs, being plaintiff number 1 and 2, defendant number 13, 15 and 16 as additional directors of the defend number 36, 37 and 46 company pursuant to a purported board resolution dated 3rd December 2021. However, the defend number 17 himself has resigned from the board of the defend number 36, 37 and 46 on 23rd December 2021. The petitioner states herein that the entire action of appointment of these directors, being plaintiff number 1, plaintiff number 2, defend numbers 13, 15 and 16, is a fraudulent attempt by the defend number 17, 12 and 15, the plaintiffs, to encumber the rights of the defend number 5 and his family. The petitioner states that all actions by the defend number 17 occurring on or after 23rd November 2011 are illegal, bad, false, fraudulent and must be set aside off from the records of the company. The petitioner states that all actions of the plaintiff, the defend numbers 13, 15, and 16, occurring on and after 3rd December are false, fraudulent, and must be struck off from the records of the company. So this is his primary cause of action. And now, my lord, what does he state after that? Why was it bad? 59. The petitioner state that no board meeting was held or could have been held on 3rd December 2021 or other day or on any other day of the defend number 36, 37, 46 for appointment of plaintiffs, defend number 13, 15, and 16. No notice of such board meeting has been given to the defend number 7 and 9 and or received by the defend number 7 or 9. The alleged board meetings, if at all held on 3rd December and all resolution passed thereunder, including appointment of D13, 15, 16 plaintiff number 1 and 2 as additional directors are illegal, null and void for the following reasons. And then he is going to reiterate these reasons. My lord, if your lordship see after 1 to 11, if your lordship takes page 49, he has annexed copies of the DIR 12s by which, my lord, which is filed with the registrar of companies to show appointment of directors in relation to all 3 companies. My lord, page 49, my lord, he has annexed the copies, annexure U, V, and W. A copy of the purported DIR 12 of 36 is annexed here to marked U, copy of DIR 12 of defend number 37, and a copy of DIR 12 of defend number 46. He's annexed these copies. My lord, will straight come. So the allegation made from these paragraphs is that, my lord, defend number 17, who was one of the directors of these companies, has resigned on 27th of November 2021. My lord, paragraph, my lord, if your lordship sees paragraph 55 and 57. Specific case. D17 resigned from the board of directors of D36, 37, and 46, and therefore the board meeting which was held on 3rd December 2021 appointing the plaintiffs and defend numbers 13, 15, and 16 is bad because defend number 17 could not have called a board meeting. This is the case which has been made out. He has annexed documents himself. We'll kindly first take, my lord, page 424 of the petitioner's documents. None of this was showed to your lordship, my lord. Page 424.
Because I restricted my submission only to injunction.
My lord, this injunction is because of this. His case is that, my lord, there's a wrongful board of directors meeting by which he has been removed.
You have disclosed that in your affidavit in opposition.
My lord, he has himself disclosed. He has not realized that he has disclosed. Your lordship sees page 424.
Page 424
of the petition. My lord, 424. Again. My lord, just give me one moment, my lord. I will just volume 1 tak utana.
Yes.
My lord, will just give me one moment. I will just. No, আমার মার্ক করা আছে, লেখা আছে. Give me just one moment. No, accept.
Plaintiff has included this in the
My lord, will
property.
take-
I'm asking for injunction.
Page 424.
Showing share certificates and
My lord,
director
this is the cause of action. Cause of action is wrong.
Page
Page 424.
deal with the property.
Whose
420.
document is this?
Well, this is the plaintiff's document. Plaintiff has annexed. Well, this is the certified copy of the resolution passed at the meeting of the board of directors of Brickworth. Brickworth is D 36, defend number 36, held at 3 Moira Street, Circus Avenue, Kolkata 17, Friday on 3rd December 2021. And my lord, what happens in these board meetings? Number 1, appointment of Rita Patodia as a director, appointment of Alka Patodia as director. These are the plaintiffs. Well, not plaintiffs, plaintiff and the defendants, my lord, referred. My lord, 3, appointment of Anil Kumar Patodia. 4, Mrs. Snehalata Patodia. And if your lordship turns over to 426, bottom 5, taking note of resignation of Mehul Patodia from the directorship of the company. And your lordship will kindly read the resolution. Resolved that pursuant to section 168(1) of the Companies Act 2013, read with rule 15 of the Companies Appointment and Qualification Directors Rules 2014 and other applicable provisions of the Act, and subject to provisions of the Article Association, the resignation of Mehul Patodia from the directorship of the company, vide resignation letter dated 23rd November 2013, be and is hereby accepted with effect from 2nd December 2021. And now will kindly takes my lord page 455, which is my lord the first page of volume 4. First page, fourth page, volume 4, page 455, volume 4 of the petition. My lord, kindly see, this is the resignation letter. The letter was issued on 23rd November 2021. He had not resigned on that day. He said, I want to resign.
Ultimately, he resigned.
Ultimately, he resigned after the board meeting. So on the board, the day the board meeting was held, he was very much a director on that day. My lord, page 455.
Yes.
Resignation letter, 23rd November 2021. It's being written to the Board of Directors of Defendant number 36. Respected sir, I, Mehul Patodia, son of so-and-so, due to personal reasons, hereby tender my resignation from directorship of Brickworth Builders Private Limited with effect from 3rd December 2021. Now, my lord, once your lordship will kindly come back again to paragraph 55 of the petition. First volume of the petition. So on 23rd November 2021, he had not resigned. It was a letter of resignation. He continued to remain a director.
Page 50,
Para 55. Petitioner state that on the petitioner in or around January 10th, 2022 was shocked and surprised to find that the defendant number 17 has appointed plaintiffs being plaintiff number 1, 2, 13, 15 and 16 as additional directors of so-and-so companies by a purported board resolution of December 3rd, 2021. However, the defendant number 17 himself has resigned from the board of directors on 23rd December 2021. That was a completely wrong statement which has been made to mislead. He was very much a director on 3rd December. He resigned on that day. The resignation was accepted only on that day. So he could have very much called a board meeting.
His intention to
He gave his intention to resign. So on 3rd December, the board meeting which was called was rightly called. There was no problem with that. His case is he could not have called a board meeting because he was no longer a director because of his purported resignation on 23rd November 2021.
And resignation, they have annexed in the petition.
And these are documents which they themselves have annexed. Now, most importantly, my lord, this your lordship takes my opposition. My affidavit in opposition. My lord, the level of suppression here by the applicant is to a different extent altogether. My lord, his allegation is that, my lord, he has lost control of the board. My lord,
so far the removal is concerned, that is admitted.
My lord, he has not been removed. He's still a director. He's not mentioned that. Will kindly see my opposition. I have disclosed documents. He is, I have, my lord, if your lordship, his
Yes,
I'll kindly sees. My lord, paragraph 38, when I have dealt with all these statements. paragraph 38, where I'm dealing with para 55 to 61.
Para
Till
38.
today, my lord, he is signing, my lord, the regular, key sign balance sheet is being signed by him till date.
Which para 38?
Para 38. My learned friend's client has not properly instructed him, my lord. Para 38.
Instructions.
Instructions are in the petition.
But documents will prove otherwise. My lord, para 38. With reference to para 55 to 60.
Yes, from which documents do we get that he is still continuing as a director?
My lord, I have
and
annexed.
not removed.
I have annexed the documents. I will show it also.
Let us see
Your
that.
lordship will kindly see the pleading first.
Yes. No, you're pleading.
My pleading, paragraph 38.
Para 38. Yes.
With reference to 55 to 61, it is denied that only on 10th January 2022, defend number 5 came to learn of the appointment of the plaintiffs or defend number 13, 15, and 16 as directors of 36, 37, and 48. The defend number 17 has resigned from the board of directors of 36, 37, 46 with effect from 3rd December 2021, and the same is evident from his resignation letter. All allegations to the contrary are denied and disputed. The board resolution of 3rd December 2021 of the appointment of the plaintiffs and the defend number 13, 15, and 16 as additional directors of D 36, 37, and 46 has been done complying with the provisions of the Companies Act and the rules framed thereunder, and all allegations to the contrary are denied. It is denied that all actions of the defend number 17 occurring on or after 23rd November 2021 are illegal or bad or false or fraudulent or must be set aside. It is denied that the appointment of the plaintiff and the defendants 13, 15, and 16 as additional director is fraudulent. My lord, if your lordship skips and goes, my lord, to the page 23, middle of the paragraph.
Yes.
My lord, the sentence starting with after my appointment.
Yes.
After my appointment as a director in defend number 36, 37, and 46, respective companies, as also directors including me, received notices dated 1st September 2022 in respect of defend number 36 and 46, and 2nd September 22 in respect of defend number 37 from Registrar of Companies, wherefrom it appears that the Deputy Registrar has received a complaint with regard to the meetings held on 3rd December 2021, 5th December, and 27th December. Well, 3rd December is the contentious meeting, which my learned friend is complaining of. These notices have been responded to in detail by 3 several letters, all dated 22nd September 2021. It has been categorically mentioned in these letters that Mayank Patodia was also present at the board meeting on 3rd December 2021. My lord, the petitioner applicant had complained before the Registrar of Companies also that, my lord, that he is not a director, and therefore a meeting of 3rd December 2021 could not have been held. My lord, after that, if your lordship.
Now, regarding the removal of Mr.
I will
Bose's
show.
client, yes,
I'm showing.
that is wrong. Why do you get that?
Yes, my lord. If your lordship sees, my lord, if your lordship regarding his appointment, will kindly see, my lord, if your lordship takes, my lord, page 26. Page 26. Well, thus, paragraph starting with thus. Thus, as it stands today, the defend number 7, after filing the present application, has caused illegalities to be conducted despite no board meeting being held, and in the alternative, by holding board meetings just by himself without notice to the other directors and illegally appointing 5 and 9 as directors in the companies and causing to register. Well, sorry, my lord, I should first show, my lord, page. Paragraph well, if your lordship, same paragraph, if your lordship just goes further down, my lord, if your lordship goes down with, it is pertinent to note, my lord, middle of the paragraph, page 26, my lord, it is pertinent to note that even after the hearing of the present application on 5th January 2023, the council on behalf of the respondent number 5 made submissions and in fact completed their submissions. The fact that the defendant number 5 and 9 have been appointed as directors of respondent numbers 36, 37, and 46 albeit illegally, was not brought to the notice of the Honorable High Court. This clearly goes to show the defendant number 5, who has filed the present application, has not come with clean hands. My lord, what has happened after this application was filed, the defendant number 5 has caused a board meeting of this company to be held and has appointed the defendant number 9 as a director. That is the subject matter of a challenge, but that was not brought on record also. Same defendant, defendant number 5. And those documents are all disclosed here. If you I will just place those documents, my lord. Those are, the lordship just gives me one moment to place annexure EFG.
So regarding the order of removal, any document is annexed.
Well, there was no removal. That is the point.
If he has pleaded that there must be a document.
Well, he has not pleaded removal. He has pleaded appointment of additional directors.
No, his client.
My lord, if your lordship comes back to the petition.
No more continuing.
Yes, defendant number 9.
Kindly.
So question is there any document that Mr. Bose's client is
My lord,
continuing as
let's see the allegation which has been made in the petition.
Question is, it is his case. You see, first is
Where is the case, my lord? Where is the case made out? Your lordship will have to see.
his removal as a director.
Where is it case made out? His allegation is of additional directors. Appointment. Kindly seize, my lord, paragraph 55.
His removal is also there in the petition.
My lord, kindly seize para 55.
Para?
55 onwards of the petition. His case is, my lord, appointment of additional directors so as to dilute his power.
So there is no allegation.
No removal. No removal. His allegation is now that there are additional directors, his vote has become lesser. It is not allegation that he has been removed. Kindly seize. Kindly seize.
You have stated that your
removal is not the case.
No. Which paragraph you have stated?
My lord will kindly. There is no paragraph that is removal. It is there is additional directors which has been appointed.
And they are, otherwise, why will they allege that no notice of purported meeting was served?
It is not his allegation. He has been removed. His allegation is appointment of additional directors on 3rd December. And removal is not a question. He has, he's still signing the board, the balance sheets. I can place those on record.
If your lordship takes para 53 at page 45.
Para
53. Yes.
Page 45.
Appointment.
So here your lordship will find.
No, para 53 of your application.
Correct.
Yes.
At page 45. Your lordship will find defendant number 9 was appointed as a director in 37 and 46.
So para 53, just a minute. Para 50, yes, defendant number.
Why are you looking at the same para I am showing? Look at the other paras, no, the removal.
Yes, 7, 8, 9 and 17.
Correct. So now, my lord, 9, if your lordship will see 9 was appointed as a director. So I was a director in 37 and 46.
Yes. Still a director.
Now, my lord, your lordship will kindly take the subsequent paragraphs.
Yes.
His allegation is that no
59
notice
kindly, yes, of course, no notice is one of my.
Removal is not the
yes,
case.
My lord, as on December 3, 2000, kindly come to para 59.
Yes.
E annexure F, annexure EF of our EU.
Here, my lord, if your lordship will take para 59, say no notice, the second sentence of the board meeting has been given to D7 and 9 and or received by the D7 and
yes.
So I was director. So what he shows that the resignation letter given, he says that the resignation letter given was with effect from 3rd December. So if it was with effect from 3rd December under company jurisprudence, on 3rd December you cease to be a director. So how are you appointing directors on 3rd December? In my absence, we were the other 2 directors.
So your absence means is there it is your contention that you had not issued notice with regard to
Yes, of course, 7 and 9. 7 and 9. I said that your lordship will see here.
My lord,
that meetings were
during
given the
arguments, it was
D7-9
placed, he has
received
been
by
removed,
7-9.
which is absolutely wrong and contrary to the case made out.
7 and 9.
7 and 9, it forms a part of my group of defendants.
Yes.
So I was the director of these companies.
Yes.
So the constitution of the board is being altered without notice to the board of directors. This is the fundamental principle of company jurisprudence.
My lord, let my
That
learned
without
friend finish.
notice,
Where
No,
during
this is a
in the first stage,
clarification.
my lord, a different argument was made. Unfortunately, it was very categorically said that he has been removed, and that is the cause of action. That was the exact argument which was made, my lord.
No, it has to be specifically pleaded.
It is not been removed. And his case is that he was that is why I wanted to show the pleadings. His case is 3rd December meeting is bad because Mehul Patodia, defend number 17, had already resigned. It is not his case that he has been removed and he's continuing to remain. He's continuing to remain.
Anyway, you submit.
Yes, my lord. My lord, may I come back tomorrow, my lord? I have another matter which is fixed.
no, my lord, kindly
Come back
appreciate
tomorrow.
one thing. If
Tomorrow.
even if I assuming for the sake of
My lord,
argument,
it
what
is my
my
chance. Let me finish. Then my
learned
learned
friend,
friend
what
will
he's
get a
saying
chance
is
of
correct.
reply.
So that
Let me,
means
my learned friend will get
as
a
a
chance to reply. I
plaintiff,
did
you
not object. I did not interfere, my lord, while he was arguing.
how can you object to the
kindly-
injunction on the property?
My lord,
My removal may
he
be
has to
bad.
make out a case.
Let him submit. Let him submit his objection. I'm keeping it on Monday.
But he has included the properties himself.
No, I want to get this clarification.
Very
Whether you are removed. You see, if you are not removed, you still have some power. Again, you can come.
He's still
But
signing direct. He's still
No.
signing a balance.
You see, your application may succeed.
Correct.
Your application may fail.
Very well. Very
But
well.
the question is, if you are continuing as a director, you are not powerless. But if they have removed you, then
Absolutely.
that's a malafide. Some consideration has to be given.
Absolutely.
That is the thing.
Absolutely.
Yes, record an order.
My lord, will Monday is a holiday. My lord, will kindly keep it on
Tuesday.
Wednesday. Very well.
Learned,
But may I take your lordship's kind leave, my lord? May I take your lordship's leave?
learned advocate for the plaintiff, learned advocate for
Defendant number 529.
529 stroke petitioner. Yes. No, just a minute. Your defendant number? Learned advocate for defendant number 47, 48, and 56. And yes, Mr. Sen is appearing for learned advocate for defendant number 12, 17 are present. Hard learned advocate for the petitioner in GA 16 of 2022. Although learned advocate for the plaintiff opposite party has commenced his submission but could not conclude the same, the matter be fixed on 14/5/2025 in the same position. Yes, what do you want?
Grateful.
My lord, my
Yes. No, this application, you have filed your opposition to this application. Anyway, let the plaintiff complete his submission on Wednesday.
my lord,
No, let the plaintiff complete the submission.
I will complete.
No, thereafter, if necessary, I shall make it Monday.
My lord, may the affidavits be kept on record?
Let the affidavit in opposition filed by the plaintiff
In
Yes,
2016
of
no, 23 is already there, my lord.
yes, 16 of 2020.
Well,
Oh, yes,
16 was
16
already
is
filed. Yes,
No,
ma'am.
these
23, 25, 26,
25 is replied.
And
Oh.
GA
This is the
23,
opposition.
23,
20,
26 and 27
GA 23, 26 and 27
and affidavit in reply in 25, GA 25.
and affidavit in reply in GA 25 filed by the learned advocate for the plaintiff be kept with the record.
Extremely obliged, my lord.
at least এইটা যেন আসে আর কি যেটা অনেকগুলো Yes, yes. Let the plaintiff complete his submission. Thereafter, if necessary, I shall keep it in on the next Monday. The plaintiff has not yet concluded.
My lord had passed.
Huh? A. হ্যাঁ একসাথে করে পরের দিন গিয়ে 16টার হিয়ারিংটাই চলবে আর এই অর্ডারগুলো রেখে
My lord had passed over item number 4. My lord, my learned friend is also here. If my lord takes it.
Item number 4.
Item number 4 was passed over, my lord. My lord, both sides are here, my lord.
So both sides present?
Yes, my lord.
Yes, call item 4.
My lord, item 4 is my application for perjury, my lord.
I am for the respondent.
Caveator in
If I
the
take
testimony.
your lordship a preliminary point of objection, your lordship. The petition is not maintainable. First of
File
all,
your opposition. You have filed.
I have not filed your lordship.
File your opposition.
My lord,
But he has
my lord,
done,
one-
your lordship, on the basis of which he is claiming, your lordship, I have taken a contrary stand. Even that particular document has been not annexed to your lordship with the annexures.
You see, you let it be, whatever you want to say, let it be on
My lord,
the
only one submission, my lord. My lord will give them a chance to file an opposition. Only one thing, my lord, in a perjury application, my lord, it's settled law today, my lord, the alleged contemner or rather the alleged person who's committed the act of perjury has no right of audience at this stage. So my lord will kindly keep that point open also for it to be heard later on. My lord will keep this point open.
Actually, service is also caused upon the.
Yes,
upon
this
your-
was inadvertent.
They should not have done it.
Yes,
Now
yes,
you
this
have
is an
already done it, your lordship.
it's an
Proof is
inadvertent.
over.
No. My lord will kindly keep that open. My lord, I'm carrying judgments of the Honorable Supreme
Kindly
Court.
keep
in
the
that.
point of maintainability open. That is important.
Both points can be kept open.
Learned advocate for the opposite party. Learned advocate for the petitioner in GA.
Yes.
4 of 2025. And learned advocate for the opposite party are present. Learned advocate for the opposite party submits that the application is not maintainable. Thus, the opposite party is granted liberty to take this point of maintainability in his affidavit in opposition. The right of audience of the opposite party, audience, the right of audience is also to be decided on the next hearing.
And you lordship, the point of maintainability to be kept open.
Yes, I continue liberty to file opposition.
কোনো timeline
Lordship, kindly allow me, your lordship, 3 weeks.
Try to see if the court thinks that
Of course.
of the opposite party this
My lord, my only submission is what the law subject to correction, my lord, is that at the stage of admission, this is at the stage of admission. If my lord thinks my application deserves to be dismissed in limine, my lord will do that. It's between me and the court. That is my submission.
opposite party is here, so let
My lord, it's as if when a plaintiff is being presented, defendant does not have a right of audience.
Now
Defendant can always come.
Before the
and later on.
presented, he has served me.
is here, okay.
My lord only keeps that point open. My lord, we'll argue it out. We'll argue it out.
Lordship, kindly grant me 3 weeks time, your lordship.
This matter appear on 10/6/2025.
10 June. In the meantime, I'll file.
11/6/2025.
11/6. In the meantime, I'll file, your lordship.
And
Affidavit be filed in the meantime.
my lord, one more submission. My lord, GA3 is another application which is pending. May that also come up on that date? It's not presently running in the list. It is connected to this matter, my lord.
GA3 of 2025 also appear on the same date.
On the
Oh,
same.
deeply obliged, my lord. Deeply obliged.
11/6.
G3 of
11/6.
2025. 24. No, bullshit. GA3 of 24.
Lordship, can it be on 12th, your lordship? My advocate on record won't be here on 11th.
12, these chamber matters are taken up.
Okay. Keep it the week after.
13.
13th.
Obliged.
So this is my application. In the last occasion, we had advanced our submissions. Well, there's an application for revocation. We have served, it's come back as refused. My lord, if your lordship sees this application, first, my lord, I have to satisfy your lordship as to how the predecessor in interest before your lordships could have had any chance at succession. But you'll kindly see the Hindu Succession Act first, my lord. This is relevant. I'll just indicate why. Well, the first page. First page.
15.
Yes, first page.
Okay.
Not no section, my lord. Before, my lord, any section. So you will see that this act has come into force on 17th of June 1956. Now, my lord, the erstwhile king who has now died, Bhuvaneshwari Prasad Singh Dev, inheritance in his favor, because my lord, the family followed the rule of primogeniture. Inheritance in his favor, my lord, opened on January 8, 1956.
Prior to this act.
Yes, my lord. So, once, my lord, the inheritance opened, as on that date, the estate of Bhuvaneshwari Prasad Singh Dev vested in him absolutely. So, my lord, the
As per section 14,
yes, my lord.
limited right of the woman were converted to a absolute right.
Yes, my lord.
If prior to this act, the
Comes into force.
woman had limited right.
Yes, my
by
lord.
virtue of section 14.
It was converted into an absolute right.
By section 14.
Yes, my lord. And, my lord, all other rules and customs which did not find a place in this statute, it was deemed that those customs will not be followed and it stood obliterated. So, my lord, the rule of primogeniture, once it opened in 56, post the statute, my lord, those customs were no longer in force. But prior thereto, it came into force, before the act came into force, my lord, prior thereto, any rule of succession which was followed by the family would apply.
Under the old Hindu succession.
Yes, my lord.
Prior to this Hindu Succession Act, the old Hindu law of succession
Yes, my
applied.
lord. Yes, my lord. So accordingly, it came to the son, the eldest son, which is, my lord, Bhuvaneshwari Prasad Singh Dev. He has a will. His will is there, and which is being probated before your lordship's court. Now, the letters of administration of which I seek revocation is, my lord, the letter of administration granted to the estate of the mother of Bhuvaneshwari Prasad Singh Dev, which is
Page 61 is the application.
yes, my lord. This is, my lord, the application filed by, my lord, the eldest son of, my lord, Ranjit Prasad Singh Dev, which was not allowed because of the delay. So accordingly, my lord, the applicants before your lordship is, my lord, the youngest daughter of, my lord, Ranjit Prasad Singh Dev. I've explained, my lord, the delay and the cause as to why she couldn't approach this court before. Paragraph 9, if your lordship sees, Hmm. May I please the same?
Para 9.
The applicant had no knowledge of the proceedings for grant of letters of administration to the alleged estate of late Durgesh Kumari Devi, instituted and granted in favor of Maheshwari till about 17th of December 2024. Maheshwari is, my lord, the younger sister of Bhuvaneshwar Prasad Singh Dev. The applicant has been married since 2017, does not reside at Panchkot Palace. However, she visits her mother and brothers once in a while. As is customary in most Indian households, married daughters are generally kept out of any kind of legal issues of her maiden family. On December 17, 2024, when she visited her brothers, she came to learn of the grant. The applicant thus came to learn of various attempts made by the said Maheshwari Devi to encumber the assets which are to devolve upon the heirs of Lord Ranjit Kumar Singh Dev, including herself. Upon learning of such circumstances, the applicant approached her advocates for necessary advice. Under the aforesaid circumstances, the applicant and Manojit Singh Dev held a conference on 11 January 2025 at the said advocates' chamber. From the joint discussion with Manojit Singh Dev, all the facts emerged for the first time to the applicant, which had been stated hereinafter. It is at this juncture she was advised to take out the present application, challenging the grant of letter of administration to Maheshwari Devi of the alleged assets and properties of late Durgesh Kumari Devi. It is also pertinent to state that in the year 97, when the alleged letter of administration was granted, the applicant was a minor. Late Bhuvaneshwari Prasad Singh Dev, after publishing the last will, which is my lord Ranjit Singh Dev's nephew, Bhuvaneshwari Prasad Singh Dev was Ranjit Singh Dev's nephew.
So on the next day, it's better you come with some short notes about
I'll do that, my lord.
and a list of dates.
And a sequence of how the genealogical table goes through. It will be convenient.
Yes, that table, list of dates and a short notes about.
I'll do that, my lord. I'll come back with it, my lord.
Yes, the Ghosh Garnet advocate for the applicant is present. Heard Mr. Ghosh on the petition EA 14 of 2025. As the hearing is not concluded, yes, when can you come?
My lord, next week, if so convenient. My lord, 19th, my lord.
19 by 2025. Stop for further hearing of GA 14 of 2025. Let the matter retain its position. Yes, Garnet Council is requested to come with the written notes of arguments and a short and a list of dates.
I'll do that. I'll do that.
Written notes of arguments and a list of dates.
Great.
Pass over item number 8, 9, 10. Okay. So,
My lord, in this,
have you completed your submission?
Yes, I had completed my submissions.
You
Your
have to reply.
we have to reply.
You will submit or Mr. Ghosh will submit.
And Mr. Ghosh requested me to start. From what I hear, he's on the way.
Take it up at 2 p.m.
Your lordship. So we'll then.
You make a witness action. We made a fix that, na? Old suit.
Well, 27. Item.
Start, my lord. After that matter, if this matter is called, we'll continue. My lord will first kindly take the written notes of submission arguments that we had filed on behalf of the plaintiff respondent. এবার একটু written notes দেবেন এই যে এইরকম দেখতে হ্যাঁ just to recapitulate
Applications are taken up analogously.
yes my lord
The petition, the amendments of the petition, you see in this item number.
GA3 and GA4.
Yes.
GA3 is their application for my lord for dismissal of the suit on the ground that
GA3 and that will be their opposition in GA4.
Right, my lord. Although separate oppositions have been filed, now kindly sees kindly sees the written notes of argument. The background facts I'll just place. Plaintiff had.
It covers both GA3 and 4.
Yes, my lord. Although it is titled as GA3, but this covers both.
GA2 is what? Application
GA2 is my application for injunction in which I am already enjoying an interim order. That interim order is due to expire on 26th of May. Before that, my lord, I'm sure we'll dispose of these two matters. So, my lord. I'll just give the background facts which have been stated before also. I'll just briefly say, kindly see. Plaintiff had filed an application being IAGA number 2 of 2024 for interim order of injunction, which was granted by an order dated July 19, 2024. In the affidavit in opposition of such application, the defendant stated that they had not received the writ of summons. Pursuant thereto, both the defendants and plaintiff filed the following two applications. 1. IAGA number 3 of 2024 filed by the defendants for dismissal of the suit on the ground of it should be not lodging of writ of summons, and Roman 2 IAGA number 4 of 2024 for leave to lodge writ of summons upon condonation of delay. Now, my lord will see defendant petitioner's case. This is the case that has been made out by my learned friend. In IAGA number 3 of 2024, defendant number petitioner is paid for dismissal of the suit on the following basis. The defendants came to learn of the interim order dated July 19, 2024, which is at page 9 and 10 of the petition, by which, my lord, an interim order was granted to me in IAGA number 2. And since the defendants had recently been elected as office bearers, so, my lord, my lord will see that the defendant numbers 1, 2, and 3 are the president secretary of one flat owners association, which is, my lord, the defendant number 3 here. So, my lord, they have stated in their application, my lord, that since the defendants had been recently elected as office bearers, they approached their advocate and came to know of the pendency of the
paragraph 3 of your arguments.
Yes, paragraph 3, Roman 1 of my arguments, my lord. I have indicated the page numbers also. Since the defendants have been recently elected as office bearers, they approached their advocate, came to know of the pendency of the suit and about the applications being IAGA number 1 of 2012 and IAGA number 2 of 2024. The defendants made enquiries with the deputy sheriff and came to know that no writ of summons were lodged. There had been substantial delay and the Honorable Court had not extended the time to lodge writ of summons, and such the suit should be dismissed. This is the, my lord, the case made out by the defendants in their application in IAGA number 3. My lord, what is the defense of the plaintiff respondent? Plaintiff had filed IAGA number 4 of 2024 for leave to lodge the writ of summons. The grounds for filing IAGA number 4 of 2024 are also the defense of the plaintiff in IAGA number 3. In the affidavit in opposition to IAGA number 3, my lord, here I would want my lord to take up the affidavit in opposition that was filed on behalf of the plaintiff in IAGA number 3. It's an affidavit affirmed by my lord one Tonumoy Roy on, my lord, affirmed on 7th of December 2024. GA3 affidavit in opposition. Yes. Kindly comes to, my lord, paragraph 4 at page 3. Paragraph number 4, Roman 1 and 2, my lord, the introductory pleadings. The plaintiff is a company, Roman 2, plaintiff instituted a suit for reliefs against the defendants. Kindly see what were the reliefs in the suit. It is in paragraph 4 at page 3 of the affidavit in opposition. Arguments are shown.
Yes.
Kindly see, my lord, the reliefs in the suit, they are important to know what is the nature of the suit. On or about July 12, paragraph 4, Roman 2, the plaintiff instituted the instant suit against the defendants herein, praying for the following reliefs. An enquiry be made by this honorable court as to the damages suffered by the plaintiff due to the acts of the defendants complained of herein, and a decree for such sum by way of damages as may be determined on such ascertainment being passed. Decree for declaration that the defendants are bound and obliged to specifically identify, separate, and ensure exclusive user and enjoyment of the plaintiff of 6 car parking spaces mentioned in the 4 deeds of sublease, all dated 30th of June 1990, by which the plaintiff acquired right, title, and interest in the suit premises. Decree for mandatory injunction directing the defendants to specifically identify and separate and earmark for exclusive user of the plaintiff 6 car parking spaces in the open car parking space of premises number 28/1 Shakespeare Sharoni. Then D again, my lord, decree for mandatory injunction directing the defendants to take specific steps and measures to enable the plaintiff to exclusively use and enjoy without any interference the 6 car parking spaces in the open car parking space of 28/1 Shakespeare Sharoni, to be separated and identified by the defendants as per prayer C above. Again, prayer E, decree for mandatory injunction directing the defendants to produce before the plaintiff the correct and audited accounts and furnish to the plaintiff bills based on proportionate share of actual expenses regarding the maintenance charges legally due and payable by the plaintiff, to enable the plaintiff to meet and pay the same. Thereafter, my lord, decree for permanent injunction restraining the defendant to prevent the plaintiff from availing of common facilities, common areas, and common conveniences. My lord, then G is decree for rupees 1 crore 20 lakh as damages. Alternatively, an inquiry be held by this honorable court. My lord, thereafter, the usual prayers, receiver attachment before judgment costs. Why I showed this prayers and reliefs to my lord? Because the plaintiff, by virtue of a lease, my lord, is holding on to 4 flats and 6 car parking spaces at the premises in question within the jurisdiction of this honorable court. The defendants are the, my lord, owners association. They are in charge of the maintenance of the property and everything. Now, my specific dispute was that despite being entitled to 6 car parking spaces, those car parking spaces have not been earmarked. So from 1990 onwards, thereafter, my lord, several car parking, we have made multiple requests, car parking spaces weren't. So we are unable to, my lord, park the car parking spaces despite having paid the entire consideration. This is the dispute. Their counter dispute is that we are not paying maintenance charges. So this is the genesis of the disputes between the parties for which this suit was instituted. Now kindly comes to, my lord, subpara 3 at page 5. So my lord will see that even if, my lord, if the suit is dismissed, the cause of action is continuing in nature. Till date, they have not identified the car parking spaces. So the cause of action for instituting this suit, my lord, is in the nature of a continuous cause of action. It is continuing from day to day. Now kindly comes to, my lord, Roman 3. As would appear from the plaint filed in the instant suit, the same was verified and affirmed by one Anand Kumar Dhanuka. My lord, the plaint is there before my lord. There, my lord can take my word. My learned friend will surely not object. It was verified and affirmed by one Anand Kumar Dhanuka, who was one of the directors of the plaintiff company. The said Mr. Dhanuka was authorized by the board of directors of the plaintiff to institute the suit. In this regard, an extract of the board resolution of the plaintiff dated March 5, 2022 was signed by one Hitesh Agarwal on behalf of the board of directors. My lord, sorry, there is a typographical error. It should be March 5, 2012, which has annexed, my lord, at to this affidavit in opposition, appearing at, my lord, page number 15. There, my lord will see it's a resolution of 2012 where Mr. Anand Kumar Dhanuka, my lord, was authorized to, my lord, plead, compromise, compound, my lord, take steps in the suit. Now, subpara 4 at page 5. Aforesaid Mr. Dhanuka used to look after the litigations of the plaintiff. In such process, Mr. Dhanuka was assisted by one Badri Prasad Agarwal since deceased. So, Mr. Dhanuka was assisted by Mr. one Badri Prasad Agarwal who has passed away. Immediately after institution of the suit, the plaintiff also filed an application being GA number 1929 of 2012, praying for reliefs in the nature of injunction and appointment of receiver. Plaintiffs claimed leave to refer to a copy of the said application. In such application, by an order dated 27th of August 2012, this honorable court was pleased to record the undertaking assurance given by the learned advocate for the defendants, and the parties were directed to exchange affidavits. Thereafter, affidavits were exchanged by and between the parties herein in respect of the aforesaid application. Subsequently, the said application was dismissed by a subsequent order dated July 7, 2014, my lord, which was dismissed for default. Now, my lord kindly sees the order passed in that, my lord, GA 1929, which was renumbered as IAGA number 1. Kindly comes to page number 16 of the affidavit in opposition. It's an order of 27th of August 2012.
Page 16.
Yes, my lord. Annexure B to my affidavit in opposition, page 16. Order dated 27th of August 2012. Annexure B, my lord.
Yes.
Now, my lord, we'll see learned counsel. So, my lord, the respondents appeared. Why I am showing this, my lord? To show that the respondents were aware that a suit had been instituted, that an application was filed, and they were served with a copy of the application for which they appeared before this honorable court. and they had assured to the court that they would not cause any hindrance to the plaintiffs enjoying the common facilities, areas, and conveniences of 28/1 Shakespeare Sharoni, Kolkata 700017. Such assurance is recorded. In case of breach of such assurance, the petitioner is given liberty to apply. It is also pointed out that the petitioner has not paid such for these facilities in such and such 1994. Let Mr. Malik submits that if bills are raised upon his clients, they would pay the admissible amount. Let this be done, and I order accordingly. Thereafter, affidavits were exchanged. My lord, subsequently, my lord, at the next page, this was dismissed for default, and all interim orders stood vacate. My only intention of showing these orders to my lord is to show that the defendants were, at least on 27th of August 2012, was aware of the pendency of the suit. Now, my lord will kindly come back to page number 6 of my affidavit in opposition. My lord, these are my grounds for delayed lodging of the writ of summons, as well as, my lord, in answer to their application for dismissal of the suit. Now, my lord, subpara 7. The deponent has come to know from erstwhile advocate on record that during the course of hearing of the said application, a copy of the plaint was in fact handed over to the defendant's advocate on record in court. My lord, there was a change in advocate of the plaintiffs. My lord, the plaintiff had obtained instruction, and from the erstwhile advocate on record, it was informed, my lord, that the plaint was handed over. Now, my lord has already seen that it's a contention of the defendants that the office bearers of the defendant number 3 association had changed. Elections took place, new president was appointed, new secretary came in, so they might not know. They are saying that they got the knowledge after this interim order was passed in 2024 in GA number 2. Subpara 8, thus the defendants were well aware of the contents of the plaint filed in the instant suit. However, it subsequently transpired that although the writ of summons was filed on time with the plaint, but the same was not lodged in respect of the above suit for service of the same upon the defendant's hearing. Such omission Now, my lord, my learned senior has pointed out an extremely relevant fact. Kindly comes to, my lord, kindly come to, my lord, page number 16 of the opposition. My lord, the order of 27th August that I had shown. The respondents had appeared through, my lord, one Mr. D. Trivedi and Mr. A. Sharma.
Page 16.
Yes, my lord. Annexure B, or the order of 27th of August passed by Honorable Justice I.P. Mukherjee, which I had just placed. Kindly sees who are appearing, my lord. Mr. S.K. Mullik, Miss Asha Gaurisaria Gudgutia, Miss L. Ghosh, Mr. S. Shaw. These are the advocates who appeared for the plaintiff, my lord. And Mr. Dheeraj Trivedi and Mr. A. Sharma, he had appeared on behalf of the defendants. This was in the year 2012. It was the specific case that a copy of the plaint was handed over to these advocates. Now, my lord will turn the page over. When the application was dismissed for default on 7th of July 2014, my lord will see Mr. Dheeraj Trivedi was there, Mr. Choyan Gupta was there, and Mr. Rajesh Upadhyay was there. Now, I do not know whether between 2012 to 2014 there was any change obtained by the defendants or not. But
here only this application was dismissed.
Yes, my lord, this application was dismissed. But the advocates also seem to be different, my lord, except for Mr. Dheeraj Trivedi, my lord. My lord will see that Mr. A. Sharma's name does not appear in the order of 2014, and Mr. Choyan Gupta and Mr. Rajesh Upadhyay advocates' names do not appear in the order of 2012. So there may have been a change, but that is not within my knowledge. That is within the specific knowledge of the defendants. Now, my lord will come back to, my lord, page number 6. Subpara 10. Such omission, my lord, that is omission to lodge the writ of summons, subpara 10 at page 6. Such omission is not deliberate on the part of the plaintiff. The plaintiff does not stand to gain from such omission. The plaintiff has already paid the court fees to the tune of rupees 50,000 and has also incurred substantial litigation expenses. The plaintiff had initially engaged Ms. Shayantini Shaw as its advocate, who instituted the suit on behalf of the plaintiff. To the best of knowledge of the deponent herein, the plaintiff never received any advice with regard to lodging of the writ of summons. In fact, there was no reason on the part of the plaintiff to not lodge such writ of summons. That may be so,
as even the erstwhile advocate on record was under the impression since the plaint was handed over to the advocate of the defendants in course of hearing in the interlocutory application, the formal service of the writ of summons may have been waived. Had the plaintiff known of such legal requirement, the plaintiff would have taken all steps required for lodging of writ of summons. Owing to such lack of information and or advice, the plaintiff could not take steps for the lodging of the writ of summons. So, my lord, here I say that I never received any advice. I am the plaintiff, my lord. I am in charge of the suit. I have filed interlocutory applications. I will not gain anything by not lodging the writ of summons because, my lord, obviously the defendants would take the point that on this ground the suit should be dismissed. But I have the carriage of proceedings. I would have definitely done it.
Come at 2 p.m. or on the next day?
My lord will kindly then fix up a date because
or Tuesday, but any day.
my lord will kindly grant.
Learned advocates for the parties are present. Learned advocate for the plaintiff in GA 3 of 2024. Fourteen.
14, my lord.
14 or 15?
14th Tuesday. Check it.
14th Wednesday.
14, my lord. Wednesday.
14/5/2025.
Will not take me amiss, my lord, for mentioning there is some urgency, my lord. Your lordship, my lord, has passed an order, my lord, directing the sheriff to take possession of, my lord, certain rooms and office spaces, my lord, in Marshall House. I came to know of this order, my lord, recently. 1st May, your lordship passed. Except persons who have filed their order 21, rule 99. So, my lord, I am only seeking, my lord, leave to file my order 21, rule 99.
Notice come at 2 p.m.
I'll come at
upon the opposite parties, or come tomorrow. Tomorrow at 10:30.
Tomorrow. My lord, I'll come at 2. I'll serve notice and comment.
Better you come tomorrow at 10:30.
Very well.
Not 10:30. 10:30 is the chamber. So after the chamber matters are over.
Then anytime, my lord, your lordship. This is chamber matter. My lord, this is chamber matter.
Is a chamber matter?
Yes.
So mention tomorrow at 10:30 in the chamber upon service of notice.
I'll serve notice and come at 10:30. Deeply obliged. My lord, I had mentioned at 1:15. I just require your lordship's leave to make a short service and move it tomorrow 10:30. Otherwise, my lord, the master will not sign, my lord. Leave is required. There are 3 applications, my lord. Leave, yes, leave needs to be granted. দিয়ে দাও দিয়ে দাও এটা কোনটা কোথায় আছে মাস্টার লিখে দাও আমি সবকটা দিয়ে দেবো deeply obliged
Supplementary list, extension of interim order, item number 1 and 2, Bhagya Lakshmi.
Lordship, item number 1 and 2, I am appearing for the petitioner.
I do appear for the judgment debtor.
My lord, the initial interim order is of November 23 and the same has been extended from time to time. The last extension was on 9th April, Lordship. And it was to be listed tomorrow before the Honorable Justice Sugato Majumdar. And the interim order is also expiring today, Lordship.
Yes, record an order. Learned advocate for the petitioner, degree holder, and learned advocate for the judgment debtor are present.
Lordship, award holder.
Award.
It's an award.
For the petitioner, award holder.
Implied.
And learned advocate for the opposite party, award debtor are present. Are learned advocates. As the interim order, it was granted earlier, expired on 7.
It's expiring today, Lordship.
Going to expire today. The same stands extended till 22/5/2025.
No. 22/5 is the day the vacation ends.
Lordship, is no.
I'm extending it up to 22nd of this month.
Text.
Yes.
Will text it.
Grateful.
City assigned matters, item number 3.
Item numbers 3 and 4 are appearing at my instance. The initial order of injunction was 19th of July 2024, which was lastly extended on 29th April.
Assigned before Justice Majumdar.
It has been assigned before, specially assigned before Justice Majumdar.
3 and 4, both the matters.
Both the matters. One is my injunction application and the other is my learned friend's vacating application. Both are listed before Justice Majumdar. It was returnable today and the interim order is also expiring today. Lordship would kindly extend the same.
Yes, record an order. Both items 3 and 4.
Items 3 and 4, Your Lordship.
Learned advocate for the petitioner, plaintiff, and learned advocate for the defendant of the parties are present. Are learned advocates. As the interim order which was granted earlier is going to expire today, the same stands extended till 22/5/2025.
Let it be placed before the regular bench or the assignee bench on a particular day.
Before the bench having determination.
Yes, my lord, having determination, my lord, on a particular day, my lord. If your lordship kindly indicate that, my lord.
I have extended it.
Extending it and liberty upon the parties.
It will appear in the usual courts.
But if your
The
lordship,
interim order will.
Lordship will extend in limited time. I'll go and mention.
Anyway, 22nd.
my lord, my lord.
Lordship has extended it till
22nd May.
22nd.
I go myself mention, Mr. Rai.
Because I cannot direct.
Yes,
the
yes. Lordship is
My lord, my lord,
correct.
my lord.
He is controlling the other way.
Grateful one.
Grateful. Yes, Mongolbar mention.
I'm opposing this application on behalf of Andrew U Limited. I have a preliminary.
Whose application is this? You are for the defendant opposite party.
Yes. All the reliefs in this application are directed against me only. My opposition is ready, but there is a delay of only 1 day. Kindly condone the delay and accept the.
Yes.
Lordship,
the reply.
Lordship, I am appearing for the plaintiffs, led by Mr. Joydeep Kaur, Senior Advocate. Yes, Lordship, the reply is ready.
Reply is ready?
Yes.
Yes.
Lordship, Mr. Kaur, Senior Counsel, has requested if the matter could be adjourned for a week.
Let it be taken up after the vacation then in that.
Lordship, 14th, 16th, any day Lordship permits.
Mr. Dotto, learned advocate for the opposite party. Defendant is present. A prayer is sought for on behalf of learned advocate for the plaintiff petitioner. Matter stands adjourned till
16th maybe, Lordship.
19/5/2000. I'm keeping it on 19th of May.
Lordship.
She posted it after. There is no urgency involved here. I'll tell you, Lordship, why I say that nobody. It's a money claim against me. In this, my lord, there is already a subsisting order passed by the trial court, affirmed by the division bench, went up to the Supreme Court, that there is a preliminary question involved in this, whether the suit is required to be is maintainable or not. So, my lord, now, my lord, the latest judgment of the apex court, my lord, following the old principle that even an interlocutory order has to wait because the jurisdiction of the court is in question.
Anyway, I'm keeping it on 19/5/2000.
So, my lord, that's why I was saying that it's pending from the suit is of 1985. So it can wait for till after the vacation.
Let this matter.
Lordship, kindly keep it before vacation, anytime, Lordship, any day. And if
Very
also,
good. I leave it to you, Lordship.
19/5.
Junior is there, my lord, Mr. Kaur is
I'm
not.
keeping it on 19/5.
yes, Lordship, 2 p.m. as it was today.
Okay, 19/5/2025 at 2 p.m.
Much obliged.
Let the affidavit in opposition, let the affidavit file be kept with the record.
Item number 28, Devirani Nondi. 29, Tascon Engineers. 30, Shambhunath Nondi. 31, Rakhahari Sarkar. 32, Bilaspur Castings. 33, Probit Choudhury. 34, Harsh Sanon. 35, Turner Marison. 36, Sarwan Kumar Jawar. 37, Photographic Pharmacy Limited. 38, NK Traders. 39, Turner Morrison. 40, Swadeshi Merchants Private Limited. 41,
36, you are for? 36. You are for the plaintiff.
37.
37. I'm sorry. I apologize. Not 37. This is the intellectual property matter.
আপনি লিখে দিন, আমি সইটা করে দিচ্ছি। লিখে দিন।
Intellectual property
Division.
division matter.
IPIB
May
division.
I place it the last order passed by the Justice Ravi Krishna. That is the commercial suit also pertaining to infringement of copyright. As per
So the matter is also, the matter is transferred to the commercial court.
It's a initially it was a
Intellectual
infringement. After it was converted into a commercial division matter.
So this court does not have determination to take commercial matters. Yes. Yes, record an order. Learned advocate for the plaintiff is present, as because the instant suit is a commercial suit.
Infringement of copyright.
Regarding infringement of copyrights, this court does not have determination. Stop. The matter stands released. The matter may be placed before the bench having determination.
My lord, I appear for the plaintiff in this matter, my lord.
Two.
Yes, my lord. My lord, an order 7, rule 11 application has been filed by Peerless General Finance, my lord.
That is J. What is that? Is J what? So for the plaintiff.
The application is for the special officer, joint special officer appointed in this matter.
Yes.
For receiving the dividend and the share.
Yes.
But now the income tax department deducted their fees from they have applied their representative assist. For that, we have made an application. That application is pending. Mr. Officer, for the special officer. While he is on his face and trying to keep it on 21st May.
Yes, on the prayer of learned advocates for the parties are present. On the prayer of learned advocate for the plaintiff, the matter stands adjourned till 21/5/2025. Yes, next.
Lordship, item number 41, I just missed it. I'm appearing for the plaintiff. My lord. I require some time to take instructions from my client. Old suit, my lord.
Yes, item number 41. Learned advocate for the plaintiff is present. On the prayer of learned advocate for the plaintiff, the matter stands adjourned. You want after vacation or before?
After.
Matter stands adjourned till 12/6/2025.
My lord, mine is 38, my lord.
Wait, let it be called on. Oh, 38.
Yes, it is
will
called
be
on.
called on. Second time.
Yes.
Second call will be given.
My lord, I was rushing.
My lord,
Yes, 40?
5, my lords.
45. Yes. You are for?
My lords, as per the last order in the matter, the SBI bank had been asked to file an affidavit. My lords,
Yes,
my
give me the
senior
order.
is here to assist.
45.
My lords, I'm assisting my
46, my lord, 46, supplementary.
45, 46, my lords. 45, 46, my lords.
Yes. 45 and 46, both. IM and metallurgical resources.
My lords, CS 296. My lords, the next item, 46.
কত 45 টাকা হলো পাস ওভার নেক্সট
46. But item 46, my lord. My lord, by virtue of an order dated 11th of February 2020, my lord, this honorable court was pleased to direct the State Bank of India to file certain documents as mentioned in the order.
Yes.
They were specifically mentioned in the order. My lord, accordingly, my lord, we have prepared that. My lord, seeking leave to file the affidavit and the competency, my lord.
Show me the order, please.
এটা দেবে এটা দাও page 7 order page 7 হ্যাঁ অর্ডারটা হচ্ছে 11th February 2020 দেখেছি কম্পিটেন্সি হ্যাঁ হ্যাঁ
But appearing for State Bank.
The State Bank of India.
State Bank of India is not a party.
No, my lord, not a
But
party.
the direction was issued.
Direction was upon the State Bank of India, my lord, to produce certain documents, the amalgamation notification, and my lord, the details of the fixed deposits.
State Bank of Travancore.
Yes, my lord.
Because this is State Bank of India Vellore branch.
Yes, my lord, Vellore branch.
And SBI Kochi.
My lord, my lord.
So you have disclosed the information as sought for in this thing. That is
Yes, my lord. Page 5 of the order, my lord.
3 and 4.
Yes, my lord.
Yes, record an order. Learned advocate representing the State Bank of India. Your which branch?
My lord, this is my lord, the stressed asset management branch.
Okay, stressed asset management
Sam
branch.
branch. Coimbatore, my lord.
Coimbatore
Yes, my lord.
is present. Learned advocate files the report which was sought for in terms of order dated 11th February 2020 regarding merger of the State Bank of Travancore resulting in SBI Vellore branch with regard to relevant records of State Bank of Travancore at the material point of time in respect of the creation of fixed deposit account
My lord.
by the defendant number 1 pursuant to the order dated 5th May 2006. Disclosure of the information regarding availing of the overdraft loan facilities by defendant number 1 from State Bank of Travancore on 3rd October 2013 until 30th September 2014 or thereafter, and to disclose all relevant records pertaining to the accounts of the defendant becoming NPA on 5th April 2019. Stop. As the report is filed, let the same be kept with the record.
Lord, along with the Wakalatnama and competency, my lord.
Along with the Wakalatnama and competence.
With the lordship's leave, my lord.
Let this matter appear on 10/6/2025.
Deeply obliged.
Wait, please, my lord. Your lordship, I appear for the plaintiff in this matter by order dated 1st of May 2024, your lordship. Punjab National Bank, which was the added defendant number 12, was given liberty to file their written statement. And writ of summons had been issued. Your lordship, no written statement has been served upon us. And so far as the other defendants are concerned, your lordship, some of them, as per my records, 3 of the defendants have filed their written statement. By an order dated 1st September 2023, the registrar original side was directed to submit a report on date of service of summons on the defendants, date of appearance, and date of filing of written statement. That report is already on
Is there?
record. Yes, your lordship.
Okay, let me see the report. Item 47.
Lordships, I appear on behalf of defendant. I appear on behalf of ICICI Bank and Kotak Mahindra Bank in this matter. Your Lordship, my instructions are the writ of summons. The writ of summons. Yes.
ICICI Bank has already filed their written statement, your lordship, as
Order at the report.
per my instructions. The
The
report is there.
and it's served upon.
Yes, as per my instructions.
So I shall stand corrected. Your Lordship.
1st of September order হয়েছিল আর রিপোর্টটা হচ্ছে 25th September. कोटक शायद नहीं दिया
7 चलছে
इंस्ट्रक्शंस लेना पड़ेगा
तो बैठा আছে
Good for defendant number.
Lordships, I am
Show her the cost item.
she's defendant number 7 and
change to Kotak Mahindra.
and 6 and 7, your Lordship.
Defendant number 6 and 7.
Yes.
You entered appearance.
No, Your Lordship, we have not entered appearance as of yet, your
But
Lordship. But
as
Your
per
Lordship,
my
as per,
my
the
instruction, ICICI Bank
already
has already filed the written statement, your lordship.
on that. Allow me to-
Report that.
So for defendant number 1 and 2 is concerned, they have filed their They have entered appearance.
They've entered appearance, Your Lordship.
So for
So the
defendant number 6 is concerned, Wakalatnama is filed along with affidavit of competency. And so for defendant number 11 is concerned, affidavit of competency along with Wakalatnama.
yes, Punjab National Bank is added as a party.
So for 6 and 11 is concerned, written statement already filed.
6 and 11. It's not met.
Lorships, defendant number 7, ICICI Bank, has filed their written statement to the old plaint. The amendment,
The
amended
change
has
in
not
the
been-
plaint, the amendment was that Punjab National Bank was added as a party. Only one party was added.
Earlier written statement was filed.
was filed, yes, Your Lordship, by defendant number 7. However, Kotak Mahindra Bank, that is Ingvesa Bank, which was later changed to Kotak Mahindra Bank. Defendant number 6 has not received the writ of summons as of yet.
But this is earlier, that is the former defendant, defendant number 6. As per the report, defendant number 6 and 11 has filed the written statement.
6 has filed the written statement.
Yes, written statement submitted by 6 and 11 through their respective were admitted. This is the report.
The numbers.
6 and 11.
Your Lordship, if I may pray, if Your Lordship directs the registrar to give a fresh report after the amendment has been carried out, Your Lordship, because
Which bank?
But you are representing the substituted defendant or the former defendant?
Former defendant, Your Lordship, defendant number 7 and 6 and
Substitute.
7, Your Lordship, have not been served by the have not been served with the amended plaint as of yet.
You ought to have been served.
Your Lordship, ICICI Bank is the substituted defendant, not the former defendant. Ingvesa Bank merged with ICICI Bank.
Plainter देखिए एकटू.
Ingvesa Bank merged with Kotak Mahindra Bank. I apologize, Your Lordship. Amendment তো অনেক দিন আগে হয়ে গেছে।
Yes, Kotak Mahindra Bank is now the defendant number 7.
7, Your Lordship.
Now,
At present.
Okay.
Earlier it was Vaishya Bank.
Yes.
So Kotak Mahindra Bank is now defendant number 7.
7.
And ICICI then is defendant number 8.
ICICI Bank, defendant number 8.
Yes, Your
Defendant
Lordship.
number 8. 7 and 8.
ICICI Bank, yes. Defendant number 8.
ICICI Bank has filed their written statement, Your Lordship, to the old plaint.
So let me seek a fresh report.
Yes, Your Lordship.
Your Lordship.
Record learned advocate for the plaintiff and learned advocate for defendant number 6 and 7.
7 and 8.
7 and 8 are present. It appears from the report of the learned register dated 25th September 2023 that personal service was effected upon defendant number 1 and 2.
मेरे पास
And
नहीं है लेकिन हाँ,
defendant
मैं
number 1 and 2 have already entered appearance. It further appears that defendant number 6 as well as defendant number 11 have also entered appearance and filed written statement.
Your Lordship, if I may indicate, the report was filed when the amendment had not been, when the plaint was not amended, Your
Yes, yes,
Lordship.
yes.
So the numbers will not match.
Now, as as it appears that the report was submitted on 25th September 2023 and subsequent thereto, there is amendment and change of the parties to the suit. A fresh report is necessary to ascertain as to whether service upon defendant number 1, 2, 3, 4, 5, 6, 7 and 8, 5, 6, 7, 8, 9, 10, 11, 12 are complete or not. Secondly, whether written statement is filed by the respondent number 1, 2, 4, 5, 6, 7, 8, 9, 10, 11 and 12. Upon ascertaining the position with regard to service upon defendant number 1, 2, 5, 1 to 12 and the written statement with regard filed by the said defendants, a report be submitted to this court by 11/6/2025. Let this matter appear on 11/6/2025.
Great. One request, Your Lordship, Ing Vesa Bank had a different address. After the amendment, it became Kotak Mahindra Bank with a
Can
different.
you order, everything is there in the record.
Yes.
The amendment.
For your Lordship.
Madam, for the respondent.
For the plaintiffs, my lord.
Who was my lord?
Yes.
Wedding my lord, if my lord, the had died, my lord, and thereafter, my lord, the defendant number 1 had died. My lord, on the last occasion by order dated 17th April 2025, wanted us to come back with an application so that the substituted legal heirs can file their written statement. My lord, may I just hand up for your ready reference, my lord? My lord, thereafter, my lord, immediately thereafter, my lord, on 23rd of April 2025, we have asked for the full cost title from the plaintiff, but till date we have not received. As a result whereof, my lord, the application could not be filed, my lord.
Want to add yourself as a party?
Yes, my lord, thereafter too. As a substituted legal heirs.
You are representing whom?
My lord, I appear for the plaintiffs, my lord, I can hand it over. I had no instruction regarding this mail, but in any case, I'll instruct my advocate on record to hand it over today itself.
But allow us to.
Learned advocates for the parties are present. As copy of the plaint is yet to be handed over.
The
amended plaint, my lord, I'll hand it over.
As the amended cost title is yet to be handed over to the learned advocate for your appearing for?
But I'm for the defendant, my lord.
For the defendant?
Number 1. Defendant 1A to 1C. 1A to 1C.
1A, 1B and 1C. Matter stands adjourned till 13/5/2025.
1A to 1. There are 4, my lord. 1A to 1D, not 1C.
1A to 1D. Yes, 13/5.
13/5. 13th May.
13th of May.
But instead of that, my lord, allow us to come back in June, my lord. So the application be ready, my lord. But they are not.
Okay, then let it be 13/6. 12/6 করে দিন।
12/6.
Grateful.
Private. Fast flow Delcom. 51 fast flow Delcom. 52 fast flow Delcom. 53 Mridula Desai. 54 Jhajar Investment. 55 Jhajar Investment. 56 Dr. Shoshi Tharoor. 57 Quicker Chemical. 58 Antariksh Vyapar. 59, Messrs. Neo Carbon. 60, Onurag Properties Private Limited.
Your
60,
Lordship, in this matter, I am for the plaintiff.
58,
60.
yes,
60.
60, yes.
Item number 60. I am for the plaintiff. There has been some problem with the department filing the wakalatnama, a changed wakalatnama. So your Lordship will grant me leave to file 1 week's time.
What is the stage of the suit?
It's a very old suit. It is suddenly appeared in the list. I'm not particularly sure what the matter is about.
Okay, on the prayer of the learned advocate,
Your Lordship will fix the matter for hearing after vacation.
prayer of the learned advocate, the matter, learned advocate for the plaintiff, the matter stands adjourned till 10/6/2025.
My lord,
Yes.
item number 63, my lord, yes, madam. I am for the plaintiff, my lord. Now I am seeking for 2 weeks time, my lord. It's a defamation suit of the chief minister. So, my lord, we have to seek instructions from her. This matter is suddenly appearing after a long time, my lord. Yes, my lord. Moha Moitro, my lord. It's appearing after a long time.
Okay, let this 63 on the prayer of the learned advocate for the plaintiff, the matter stands adjourned till 16/6 to, I'm giving it after vacation, 16/6/2025.
My lords, I'm for 68.
Yes, item
Item 68, my lords.
68.
My lords, this is my suit for recovery of possession, but it has become infructuous as of now because the other co-owner had gone up to the Supreme Court. They have preferred an SLP. We had preferred an SLP to the Supreme Court, and that got dismissed. So their Order 7, Rule 11 was accepted as upheld. The order of the division bench was upheld. So
The suit is already dismissed under Order 7 Rule
yes,
11.
my lords. So it is, I
Where
think.
is that order?
My lords, I'm carrying the Supreme Court order, and if my lords want the division bench order, it is there with me.
Yes, if you have it.
এইটা একটু দেখে দাও।
এটা পাস করলে পাস ওভার আছে। এর নাম হলো উপমা ভট্টাচার্য। পাস ওভার।
না, ওটা আমার কাছে নেই। না, না, এটা অর্ডার। সার্টিফাইড কপি অফ দ্য অর্ডার।
তারিখ এস আনোয়ার।
হ্যাঁ, হ্যাঁ।
You have the order of the division bench.
Yes, my lords, but it is in the file.
Yes, suit
My lords,
was dismissed
yes, my lords, that
by
I,
the appeal court.
yes, my lords. So because there are three co-owners in the suit premises. One of the co-owners had not consented to the determination of the lease, which is why they had filed the Order 7 Rule 11, my lords. And they have now the current position is that, my lords, we have already filed a fresh suit due to a flux of time. The lease has come to an end. So this particular suit doesn't really serve.
Yes, it has become infructuous
Yes, my
and
lords.
dismissed also.
Yes, my lords.
Learned advocate for the plaintiff is present. It is submitted by the learned advocate for the plaintiff that by order dated 12 November 2014, passed in APOT 608 of 2014 with APOT 608 of 2014 in connection with CS 198 of 2000, no, APOT 608 of 2014 and APOT 609 of 2014. The Honorable Division Bench was pleased to treat CS 198 of 2013 being the instant suit
Yes, my lords.
as dismissed. Although a special leave petition was preferred against the said order, but the same was also dismissed. However, in the eye of law, this CS 198 of 2013 being already dismissed by order dated 12 November 2014 in APOT 608 of 2014 with APOT 609 of 2014. No order can be passed in the instant suit. Let the suit go out of the list.
Plaintiff mala old should have taken 2 weeks time because I have to take instruction from client. In this matter, some part has been settled between the parties, but the suit is pending.
Okay, let it appear after vacation.
After vacation, Karma.
Okay, item 73. On the for the plaintiff is present on the prayer of learned advocate. The matter stands adjourned till 12/6/2025.
बाल 74 Rajshekhar Agarwal.
Same order.
My lord, I am appearing for. My lord, I am seeking leave to appear virtually. My lord, I am appearing for defendant number 13 in the suit.
Just record learned advocate for the plaintiff and learned advocate for the defendant number 13 are present. আর বাদ বাকি যা ছিল তাই থাকবে।
Grateful, my lord.
Matter is adjourned after vacation.
Grateful, my lord.
75 Srikant.
75 I am appearing on the plaintiff mala. After vacation, I have to take instruction.
Okay, same order.
My lord, then 76 had been appearing for the plaintiff. My lord, but then there is no contact with the plaintiff, my lord. My lord, I was humbly praying before my lords, if lordships is pleased to discharge me from this matter, my lord. I was seeking this.
You seek instructions. If
My lord, they are not contactable. Possibly, my lord, this Videocon Industries, my lord, does not survive, my lord. It has amalgamated, my lord. They are no contact. My lord, it's very difficult. Lordship will kindly discharge me if required. Lordships may direct the registry, my lord, to serve a notice directly upon the plaintiff.
yes, 76. Learned advocate for the plaintiff is present. Learned advocate submits that he has not received any instructions till today and he is unable to contact the plaintiff. In the facts and circumstances, let administrative notice be issued upon the plaintiff as well as the defendants by 18/6/2025. Let this matter appear on 25/6/2025 for report.
Lordship will kindly discharge me from the matter, my
That
lord.
I cannot pass that order. It is your client who can discharge you.
No, lordships can. Lordships,
How?
lordships can. My lord, I have to take your lordship's leave, my lord. Leave to retire.
Anyway, for the time being, let it remain.
77 Besat Cake Shatti Iron and Steel Private
Lordship, I'm for the plaintiff, Your Lordship. The matter is coming after a long time, Lordship. I'm praying for adjournment. If it can be kept after the vacation, Your Lordship.
77 on the prayer of learned advocates for the plaintiff.
Yes, Your Lordship.
The matter stands adjourned till 16/6/2025.
$78 Bonanza Infrastructure Private Limited. Second call. All suits. Item number 28.
Not today.
29.
Not today.
30.
Same.
31.
Same.
32.
Same.
33.
Same order.
34. 34.
33,
34, Your Lordship.
34, yes.
34, Lordship. Lordship, I am appearing for the plaintiff. In terms of your Lordship's last order, I had forwarded a copy of the last order to the defendant, and again, I had sent a notice by way of mail to come over for the discovery and inspection of the documents of the plaintiff. The defendant this time, my lord, had replied. He said he is in some personal difficulty and wants to take some further time to conduct the discovery and inspection. So I leave it to your Lordship.
Item 34 on the prayer of learned advocate for the plaintiff.
No, my lord. The defendant has requested for some time. He's not here.
Defendant is not here. I am just recording your submission.
Lordship, may I make a humble submission before your Lordship? May I pray, Lordship, because the vacation is coming soon, my lord. In the time being, my lord, may the defendant take inspection of my documents and serve me an advance copy of his own affidavit of documents and let me take inspection.
Item 34, learned advocate for the plaintiff is present. It is submitted that, yes, on which date this order was passed?
Lordship, just 21st of April, my lord.
By order dated 21st April 2025, the parties were permitted to take inspections of to complete the discovery and inspection, but the same is not complete till today. Thus, this matter stands adjourned till 11/6/2025.
Lordship, the discovery and inspection may be completed by both parties in the meantime, and we may come back for issues, my lord.
The discovery and inspection shall be completed by 9/6/2025.
And we may come back for issues, framing, my lord.
11/6/2025.
For framing, my lordship.
Let it remain in the same position, 11/6/2025.
Grateful.
35. My lord, I appear for the plaintiff. My lord will kindly keep this after the vacation, my lord. My lord, he's also.
Yes, learned advocate for the plaintiff and learned advocate for the defendant are present. On the prayer of learned advocates, the matter stands adjourned till 9/6/2025.
My lord, that will be perhaps just after reopening, my lord. A week after that. Oh, on the day.
16/6/2025.
I'm so grateful.
Lordship, I appear on behalf of the plaintiff.
Appearing on behalf of the defendant number 4.
Lordship, I
Yes,
appear
what
on
is the
behalf of the
stage
plaintiff.
of
Yes,
the-
my lord. Prior to going into the stage, my lord, there was a question put upon me by my lord on the last occasion when the matter had appeared. My lord, on the basis of a report submitted by the department, had sought me to clarify whether there are defects pending in respect of the suit or not. Apropos that, my lord, may I make one submission? If my lord kindly takes the order dated 22nd of February 2024, passed by the audit bench of the erstwhile court having determination, my lord. In paragraph 2, there was a report filed by the section officer. State, my lord,
Give the order.
may I hand over, my lord? I have a soft copy.
দেখুন তো orderটা 22 তারিখে।
My lord, may I place the order in its entirety? Possibly it will be easier for my lord. From per court, my lord, Mr. Kushal Chatterjee, learned counsel, appearing for the plaintiffs. Mr. Varun Kothari, learned counsel, is appearing for the defendant number 1. Mr. Karnani, learned counsel for the defendant number 2. Mr. Das, appearing for the defendant number 4. Mrs. Madhupriya, learned receiver, is also appearing in person. The section officer attached to the office of the master and the official referee of the original side has submitted a report wherein it is informed that the plaintiffs have rectified the defects. Lord, for the purposes of placing reliance on this report, possibly remainder, my lord, I'll place just for my lord's convenience. Counsel for the defendant numbers 1 and 2 submit that they will accept notice of summons. It goes on to the merits at the stage that was at that time, my lord. For the purposes of defects, my lord, possibly my submission would be that A, the defects are cleared. Second, my lord, coming back to my lord's question with respect to what stage the suit was at, my lord, it has come to the knowledge of the plaintiff and my advocate on record. I have instructed my advocate on record to issue letters, my lord. The defendant numbers 3, 5, 10, and 12 have passed. Their legal heirs need to be brought on record. Lord, since this is a suit for partition and administration, the suit does not abate as against them.
So let the matter go out of the list with
Yes,
liberty
ma'am.
to mention.
My lord, kindly keeps it. I will have to take out a formal application to implement them.
It's better let the matter
Yes,
go
my
out
lord.
of the list.
Yes, my lord. My lord kindly does that.
Item 39.
36, my lord.
36, yes. learned advocate for the plaintiff and learned advocate for the defendant are present. As necessary steps is required to be taken for substitution of the deceased defendant.
Defendants, my lord.
This is defendants. Let the matter go out of the list with liberty to mention after taking necessary steps.
Extremely obliged.
Not today.
Lord, I appear for the plaintiff, Lord. If it comments to your lordship, Lord, may it be after the petition. 12th. Lord,
Okay, on the learned advocates for the parties are present.
On
the learned advocates for the parties are present on the prayer of
Lord, the suit is, Lord, I'm Lord, informing my land friend, Lord, this suit is for recovery of Lord municipal area and municipal taxes. Lord, I'm requesting my land friend, Lord, to have the instructions, Lord, on this matter, Lord. They are with the advocate on record, Lord, who appeared in the matter, and Lord, is in Rajya Sabha now, Lord. Which is why, Lord, I think, Lord, my land friend would be appearing afresh.
The another shoot where is that file for the eviction. Now that matter is pending even is today before Justice Patana.
This is not this matter.
No. So regarding this one for tax and all this, it's not yet. Now, if it is amalgamated or my lord want to.
Lord, may it be after the vacation, Lord, we shall come back.
Learned advocate for the parties are present.
And for the defendant number 4, my lord.
On the prayer of
sorry, no, not this matter. Sorry.
On the prayer of learned advocates, the matter stands adjourned to
12th, it comments to your lord.
12/6/2000.
12 this June.
12/6.
Yes.
2025.
Yes.
39.
39.
Appearance at the
Yes, not today.
Lordship, this is my application for yes, 43.
Yes.
My lord, this is my application for substitution, my lord. My lord, this is a suit for partition, my lord. One of the defendant, defendant number 9A, Indira Kejriwal, lordship, has passed away in 2024, August 2024. My lord, the communication was received by us on.
You have served copy upon.
Yes, I have served all of them. The appearing parties who are represented by their lawyers, I have served them. While probably they doesn't appear.
Okay. Yes, give the records. G18.
Yes, lordship. G18, lordship. Well, Lord, I'll be seeking orders in terms of prayer.
ये record टा देखिए.
Yeah.
G18 record टा देखिए.
G18 टा देखिए.
Yes.
No, lordship, that matter, I am told by my learned senior friend that the matter is set.
No. I just wanted to have him.
I've kept it after vacation. You take instructions.
Yes.
Lordship can
I
keep
said
it
we
in.
shall come back after the vacation, my lord, with the proper
No,
instructions.
what I said is, instead of keeping it for hearing, lordship can keep it for to be mentioned and then.
You will let it retain its position.
After এটা করে দেব. Probably the records have not come before this court.
The G18 has not come.
Your officers are.
Okay, let it be not today.
Lordship.
Not today. Not today. Same. Same. Same.
78, my lord, I appear for the plaintiff, my lord. I have instructions to withdraw the suit, my lord.
Yes, record an order. Learned advocate for the plaintiff is present. Learned advocate submits a letter issued by the plaintiff with an instruction to withdraw the instant suit. Upon perusing the notice issued by the plaintiff to the learned advocate, and upon hearing the learned advocate, this court is of the view that the plaintiff should be permitted to withdraw the said suit. Thus, the suit is dismissed for non-prosecution.
Grateful, my lord.
Or interim orders, if any, stands vacated.
I appear on behalf of the defendant number 10.
I beg to appear on behalf of the plaintiffs, my lord.
My
My lord, I appear for the applicants in item number 79, which is GA 15.
Behalf of the 1 to 11, my lord. My lord, defendant number 6 has already been died, but death certificate has not yet been received, my lord. Today is the Saath ceremony of defendant number 6, my lord. Kindly give me, my lord, 1 week's time, my lord. Next week, I affirm
My lord,
this.
they can file the application by the doctor certificate which they obtain. My lord, this is mere, my lord, defendant has died, my lord, they can do it.
11, my lord.
Defendant number 1
1 to 11, my lord.
Who is here for the plaintiff?
I am for the plaintiff, my lord.
Lord, I appear for the applicants in GA 15. I have not been attended as party. I have prayed.
No, did you file any application for substitution after obtaining the information? You are the plaintiff.
My lord, on the last occasion, it was indicated by one of the defendants that defendant number 6 has died. My lord had indicated that any of the parties can file an application, and my learned friend appearing on behalf of defendant number 1 to 11 except 10, he took the responsibility to bring it on record by way of an application. That was the understanding, my lord, before my lord on the last date.
Certificate has not yet been received, my lord. Today is the Saath ceremony of defendant number 6, my lord.
Lordship, that is not a problem. Lordship, may I indicate? Let them at least say that the person who has died is
Of the advocate on record of the deceased defendant.
absolutely, Lordship. What has happened? May I indicate? If a person has died within the jurisdiction of Calcutta, which falls within the jurisdiction of Kolkata Municipal Corporation, I must say, speaking from personal experience, and this is the law now, a death certificate is issued within 4 hours. The moment it is put to the burning heart, within 2 hours they get the
Defendant 1 to 11 except 10, my lord.
What is my
Right.
Defendant number 6, my lord. 6.
Who represented the defendant number 6? Did the lawyer of the defendant number 6 intimate about the death?
Yes, on the last occasion, his senior, may I assist the court? Wait. On the last occasion, his senior was there, who was representing all the defendants, 7 except defendant number 10. Defendant number 10, I am appearing. He informed the court that someone has died, defendant number 6 has died, and he will take out an application to expunge the name.
Recorded in that order. Let me see the order.
একটু জজ সাহেবকে লাস্ট অর্ডারটা দিন কোন সময় কপি থাকবে
and my lord, on dear official his statement of accounts, my lord, I have done so, and I have also filed a report in the form of an exception, they have filed an exception to my commissioner's report, defendant number 10. So, with the leave of the court, may I file the commissioner's report?
Let a copy be handed over to us.
Exception is filed by whom?
Exception was filed by defendant number 10. Lordship, there are certain.
No, here defendant. No, here it is stated that defendant number 6 died and
Yes.
all legal heirs are on record.
Yeah, they are already on record, and
So if that be so,
only the name needs to be
that
expunged.
simpliciter furnishing of death certificate is sufficient.
Yes.
And the names can be deleted from the
Yes.
record.
We are not staying in Mars that it will take 7 days for the death certificate to come. This is just a ploy.
Only 1 week's time, my lord, it may be given, my lord.
Commissioner's report is already filed.
Yes.
My lord,
Your Honor, if I may kindly indicate, the previous bench who was taking this matter, this honorable judge, had indicated that the commissioner should file periodic reports. The commissioner has been filing periodic reports, and to those reports there are certain exceptions which I took because there were serious allegations against me, and I shall place on records what are those allegations. I have already filed my exceptions, and all the respondents were given an opportunity to file their opposition to my exception. And I have not received any. I have not received anything.
my lord, let me make my submission, my lord. As per your order, my lord, you have asked me to the account as to till date, the consolidated fund, my lord, and you have pleased to grant the remuneration, my lord, last time. For the 6th of it. And my lord, I was told that exception to the commissioner's report, my report, was filed by defendant number 10. So naturally, I have given filing an interim report in the form of an exception to the report filed by the defendant.
Let a copy be handed over to me.
Definitely, I'll hand over the copy, but I have to
Yes,
file before the
yes.
Yes, for an order.
Your Honor, in the meantime, Your Honor, may I kindly indicate what has happened? In the meantime, what has happened? Defendant number 7 and 8, they no longer stay in the dwelling house. They have moved out in the month of January or February. This information was brought to the notice of the partition commissioner by the defendant number 10. Thereafter, what we see in the last report, which was filed by the partition commissioner on this was filed on 20th March 2025, if I'm not wrong. There, the partition commissioner does not take any steps. In fact, in his report, he acknowledges that yes, some new tenants has been inducted. Now, Your Honor may kindly see, this is a dwelling house. Some society has been inducted as a tenant. I can't even call them as
Anyway,
tenants.
on the next day, let me take up this exception.
Yes, my lord.
This
one, my lord, as per the commission is
My lord, this is not GA point. Item number 79 is GA 15. This is not GA 15 is being discussed.
My learned friend will show what is GA and what is not. These are part of the exception.
No, GA 15 is filed by whom? You.
GA 15.
GA 15 is filed by my learned friend who is
filed GA
appearing
15.
online for addition of party. They want party to be added. GA 15 is item 79. So let us, my lord, assist the court to take the items one by one. Now for GA 15, my lord will see from the last order passed by the previous bench on 20th March 2025. My lord may kindly takes up the order. For 1, 2, 3, 4. My lord will see that on the prayer of the learned advocate, this is, my lord, page number 2, 1, 2, 3, 4, 5th para. On the prayer of the learned counsel for the plaintiffs, it is hereby directed that original documents disclosed in the affidavit in reply shall be produced before this court for inspection by the plaintiffs. This was, my lord, solely for disposal of GA number 15.
So, what application for addition of party was
yes,
taken?
my lord, may I just give a brief two-liner summary? two-liner summary. My lord, that there was a preliminary decree. When this preliminary decree was passed, my learned friend's client, they were not there. Now they have previously also they had come up with an application claiming that they are also heirs whose names have been left out, but that application they was finally withdrawn. Now they have again come up with an application claiming themselves as heirs of one of the party whose names have been left out. Now they wants to be added as party.
Already there is a direction that GA 15 and GA 16 will be taken up for consideration. Okay.
GA 15 has to be considered first, because that is my application for addition. Previously, my learned friend is right. Previously, we filed an application. This honorable court granted us the leave, my lord, to withdraw it and file it afresh. We have filed it afresh. Thereafter, my lord, all the pleadings are complete in GA 15, which is an addition of party application, and my lord,
11 accepted 1 to 9 and 11, and defendant number 10 and learned partition commissioner, learned advocate for the defendant number 1 to 9 and 11, learned advocate for the defendant number 10, learned advocate for the defendant number 12, and learned advocate representing the partition commissioner, and learned advocate for the intervener applicant seeking to add himself as a party are present. As there is already a direction that
My lord, learned advocate for the plaintiffs is also present, sir, my lord.
2024 shall be taken up for consideration. Let the said application, hearing of the said applications be fixed on. Yes, when shall I fix it? Before vacation or after?
Yes, before vacation.
After vacation, my lord.
My lord, before vacation, my lord. We can do it, my lord, any day, my lord, subject to your lordship's convenience.
On 25, 2025, affidavits to the said
25, perhaps I think the
summer
20th of May 2025. Affidavits may be filed to the said applications. In the meantime, let the interim report filed by the learned partition commissioner be kept with the record.
My lord, one point, my lord. For disposal of GA number 15, it was directed previously by the court to the applicants of GA number 15 to produce the original documents for inspection by the plaintiffs.
The application thereafter I shall see.
No, that was, my lord, that order is already there, recorded by this honorable court.
By that order, it is there.
Yes, my lord, this is order 20th March order. My lord, kindly takes the 20th March order.
An order is there, he will comply that order. I shall take it up for consideration on the next day.
Grateful, my lord, grateful.
Whatever it is, yes, I have recorded that. Yes, that's all. We have to rise at 3:30 today.
Yes.
Published.